Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Case number 19-3071, United States of America versus Russell Harrison, also known as Russ, appellant. Mr. Orenberg for the appellant, Mr. Coleman for the appellee.
Good morning, Mr. Orenberg. We'll hear from you.
Thank you, Your Honor. Good morning. May it please the court. My name is Alan Orenberg. I represent Russell Harrison in this case. I would first like to address the issue that the district court imposed a substantively and procedurally unreasonable sentence when it imposed an upward variance and sentenced Mr. Harrison to 50 months over the applicable sentencing guidelines. The district court, in my view, improperly deviated from the rules that are clear that when there is going to be a variance in this case, there must be justification to sufficiently compel to support the degree of the variance. I'm citing to the case United States versus Brown of this circuit from 2015. In addition, the trial judge in any case when there's going to be an upward variance must state with specificity the reason for the imposition of a sentence different from that described by the appropriate guidelines calculation. In the case of Mr. Harrison, the guideline calculations was 60 months or 5 years. The district court eventually imposed a sentence of 110 months, which is 60 months higher, 50 months higher than the 60-month sentence that is prescribed by the guidelines. For whatever reason, the district court did not, in the sentencing hearing, describe with specificity the reasons why he varied upward. In fact, if I can draw the court's attention to the appendix, page 167 at the bottom, through almost the bottom of page 168, the district court in this case made some general observations about sentencing procedures. And in conclusion, he just said, I've taken in consideration all three approaches that have been advanced. There have been considerable discussion about calculation of a sentence using the advisory sentencing guidelines. And quote, I have demonstrated to the court, I've come up with what I think is a fair sentence as I can under the circumstances. Well, there's no specificity given by Judge Leon in this case.
But Mr. Orenberg, in fairness, Judge Leon on page 167 references his prior concerns. And wasn't there a hearing of some sort in May in which various aspects of the sentence and concerns that the court had were discussed?
Yes, Judge Jackson, the sentencing began back in May, it concluded in September. Yes, back in May, there was considerable discussion about the court's proposed variance at that time. But my concern is, and what I raise here is not only in the transcript in the final sentencing hearing conducted in September, but that on the statement of reasons itself on page 218 of the appendix, at the very bottom, section D, state the basis for a variance. Again, Judge Leon just gave a quick two-sentence statement, quote, severity and consistency of criminal conduct, some of which is violent in nature, including stabbing of a fellow inmate while pending sentence, protection of the community and the defendant, deterrence, both specific and general. This is a very short, concise, statement of reasons why he gave this variance sentence. When I submit to the court that he should have been more detailed, he should have been more thorough.
Mr. Orenberg, even if he was more detailed in the statement of reasons, would that have satisfied the law with respect to his obligation to give the reasons at sentencing? I guess I'm not sure why a detailed or not detailed statement of reasons matters in terms of the determination of whether he was procedurally unreasonable at sentencing.
Well, I'm going to stand by the United States Code itself, 3553 C2, which requires the court to state with specificity the reasons for the sentence or the variance in this case. And it's my position that he did not do so in a proper manner.
Suppose we think the first statement was adequate, but was given at the wrong time. So yeah, there's a legal error. There may be a legal error to the extent the statement of reasons wasn't given at the moment of sentencing. But we know perfectly well what the judge was thinking and why he thought a sentence substantially above 5 years was appropriate. So on the procedural point, what would be the point of remanding for him to just say that he meant what he has already told us?
Well, with regard to the procedural point, I'll also direct the court's attention or remind this court that I submitted that Judge Leon used some improper factors when considering the variance.
Fair enough. That's a separate point. Just on the failure to state, usually procedural reasonableness remands are when the district court doesn't say enough. And here, putting aside the Fourth Circuit issue for a moment, let's just assume he did say enough. He just didn't say it at exactly the right time. It seems to me like a case where there's an error, but no prejudice.
Well, the prejudice to my client is he's the one who's doing the additional significant time. Whether or not Judge Leon did it at the appropriate time, I don't, well, my position is he did not at the conclusion of the sentencing hearing or very near the conclusion of the hearing adequately and with specificity explain his reasons why he was going to vary upward in such a dramatic, considerable amount.
So you're saying that the timing does matter?
Yes.
So even if he had at the May hearing explained extensively what he was thinking at that time, the sentencing was in September. And is it your position that when he imposed the sentence, he needed to repeat perhaps what he had previously said?
Yes, Your Honor, that's my position. And I don't think anyone would disagree that Judge Leon has the adequate wherewithal to repeat or to fully explain his reasons, but he didn't do so at the appropriate time, which was at the sentencing hearing in September of that year.
All right, so can you talk about the significance, if any, of the discussion of the Fourth Circuit standard and Winstead? I understood you also to be concerned about the potential that the district court actually relied on an improper factor. So why is it improper?
Well, I mean, it's improper because the government chose where to bring this prosecution. Okay, it chose to bring it in the District of Columbia. It could have brought it in Maryland or perhaps elsewhere if there was a legal nexus of doing so. And I think the government should be held to the law of our jurisdiction because it chose to bring the prosecution here in the District of Columbia. It's somewhat unfair that the government later on in a sentencing posture now brings in, and I'm going to say infects the sentencing process, the sentencing discussions that were had with this argument that but for the fact that he could have been prosecuted in Maryland, he would have received a 15-year mandatory minimum. I think that it was improper for the government to raise that before our district court in the District of Columbia.
But can I just ask you, because there is an applicable sentencing statute and principle related to unwarranted sentencing disparity.
Correct.
So I'm wanting you to explain what you mean that they couldn't talk about what would happen elsewhere. I mean, I understand he did not choose to sentence him or did not choose to prosecute him in Maryland, but does that mean that nothing about another jurisdiction is relevant at the current sentencing?
No, I'm not saying that, but I'm saying, given the full background of what happened in this case, including, there's referencing to his, at that time, he was pending sentencing in another case in the District of Columbia for assault within the DC jail. The culmination or all of that infected the sentencing considerations of the district court in this case.
But how is it infecting in some sort of an improper, pejorative way for the district court to consider other criminal conduct, i.e. the stabbing in the jail, or as Judge Jackson mentioned, the need to prevent unwarranted sentencing disparities, which is explicitly set forth in the statute 3553A?
Well, that's a very good point, Judge Wilkins. Sure, the court is free to consider all the factors under 3553A. But I guess in the heat of the discussion that the parties were having in May at the initial sentencing hearing, it elevated the stakes, if you will, for Mr. Harrison to the point where he stood convicted of only 924C. The guidelines was a flat 60 months. All of a sudden, the government's asking for 132 months. The defense at the time was asking for a range, I believe it was 75 to 81 months, which sounded like a reasonable proposition for the court to consider at that time. But the court nevertheless went to a higher amount of 110 months without, in my view, improperly or somehow considering all these factors when it just should have considered initially considered the flat 60-month sentence for the 924C. As I pointed out, Mr. Harrison is admittedly, or in my view, a minor role player in the overall conspiracy of the case. There was one other gentleman, the leader of this case, who got a sentence of 192 months. 4 others in this case received far less sentences than Mr. Harris, and 2 of the co-defendants are yet to be sentenced in this case. But Mr. Harrison was a minor participant when it came to the drug conspiracy activity. Sure, when he was arrested or in his home was found a large cache of weapons and ammunition, but that's all it was, and that's what he pled to, was the 924C count. I notice I'm into my rebuttal. I think I'm in my rebuttal time, but that's what purple means. So I'd like to reserve a little bit to respond to Mr. Coleman.
Before you do, Mr. Orenberg, can I just ask you one more question, please?
Sure, please.
I'm interested in your ineffective assistance claim, and I want to make sure that I understand exactly what you're arguing. In the blue brief, you say that Mr. Harrison's Superior Court counsel fell short because he failed to continue the Superior Court case. And I'm trying to understand whether, in using the term case, you're referring to the case as a whole, including both failure to delay the plea to the new misdemeanor infraction and the sentence, or are you saying that it's ineffective just because the sentence was not delayed?
It's the latter, Judge Jackson.
All right.
With that, I'd like to reserve a little bit of time for rebuttal.
All right, we'll hear from Mr. Coleman.
Good morning. May it please the court, Nick Coleman for the United States. I'd like to begin by addressing appellant's arguments about the substantive and procedural unreasonableness, as he argues, of his sentence, and then answer any questions that the court may have about his other 2 claims. I think it's important to note here, appellant had, first of all, prior convictions for assault with a dangerous weapon, carrying a pistol without a license, attempted possession with intent to distribute PCP, and attempted possession with intent to distribute cocaine in his record. In this offense, he had 6 loaded semi-automatic weapons in his apartment, an additional 80 rounds of ammunition, a firearm silencer, and 3 gun magazines, one of which could hold 50 rounds. While he was awaiting sentencing, in this case at the jail, appellant apparently more than once stabbed another inmate with the help of another inmate. The entirety of that record made clear why the district court varied upwards and why defense counsel didn't ask for a more fulsome explanation, even when there was, the district court did say at the end of the sentencing proceeding, are there any questions? And
Mr. Coleman,
appellant and his counsel did not have that.
Can I just ask you a couple things? First of all, it would seem to me that the statute is such that regardless of how clear a record may be concerning the various factors, the district court is obligated to state at sentencing the reasons. Am I wrong about that? I mean, we don't have a world in which the district court can say 2 lines, I'm imposing a fair sentence, and even as clear as the record may be, that's enough, right?
I think that's obviously, yes, that is what the statute says. I think it is important to note that this case does, and this claim does come before this court under the plain error standard of review, because appellant did not object and say that's an insufficient and inadequate statement of reasons, Your Honor. I think this court needs to be more specific. So I think at that point, even if this court were to say, look, that's error, we still have to answer the question, on this entire record, was there sufficient prejudice to him? And was that error so plain or obvious this court needs to step in and say, we have to remand this for essentially more reasons?
What about the potential that the district court relied on an inappropriate factor? Because to the extent that you are suggesting, and maybe you didn't in your recitation, but are you at all relying on the Fourth Circuit Winstead issue? Because that was a big focus of the previous hearing.
Okay, so I think it is very clear. First of all, it's hard for me to completely understand appellant's argument about how this was an improper factor. It certainly would have been improper, obviously, if the district court had said, I'm just going to treat Winstead as not applying in this case, either because, well, he pleaded guilty before Winstead came out or whatever, but I'm going to apply the career offender guideline. We know that Judge Leon did not do that here because he doesn't impose a 15-year sentence. He varies upwards, but not anywhere near the 180 months.
Mr. Coleman, we don't know, right? Because he doesn't tell us what he's relying on. He imposes a sentence that is greater than the guideline sentence, but yes, admittedly less than the 15 years. And I'm not sure there's anything in the record that explains how he reaches the number that he reaches. Do you see that somewhere that I'm not aware of?
So he does not specifically announce why why 110 months. I can say this: if you look at the entire record again, the government asked for a 132-month sentence, which would have been an upward variance of 72 months. The defense, obviously, it still stated its preference was for 60 months, but said in the alternative, if you're going to do a variance, do 70 to 87 months. So that would have been an upward variance of 17 months at the top. The 50-month upward variance that the court arrives at is just above the halfway point between the government and the defense recommendations. So I think any idea, first of all, that that this court, that Judge Leon was relying on Winstead to say something. I'm not entirely sure what it is that the appellant is saying was improper here in terms of thinking about how appellant might have been sentenced if he had been prosecuted in Maryland as opposed to the District of Columbia.
But doesn't Judge
again, we don't concede that that's improper.
Coleman, isn't Winstead a subject, an extensive discussion in the May hearing, and the district court says at one point, it's just a benchmark, right? It's just a guide. He never purports to suggest that he will actually apply the Fourth Circuit standard, but when the objection of the defense comes that it's improper to consider it, the district court appears to defend the consideration of that factor. It's a benchmark, he says. So I don't understand how that's inconsistent with thinking that he may have reached 110 months on the basis of that benchmark in part. He doesn't have to hit it in order to rely on it, right?
So right, that's why I'm trying to distinguish between two things, and I'm sorry if I haven't been entirely clear about that. It would be, there are two ways in which consideration of that, could have been taken. One would have been error, and which would have been to say, I'm not going to apply Winstead. I think it's unfair. Okay, that would have been an error because obviously this court's law applies. And at that point, in order to correctly apply the guidelines, the court could not apply the career offender enhancement. That is not what the district court does here. There is another aspect of this, however, which is to consider the entire record of the case, and as well as such considerations as avoiding unwarranted disparities between how somebody sentenced in Maryland for the same conduct would have been sentenced versus the District of Columbia. That in his discretion, the district judge can consider things like that. And I'm not aware of any decision of this court that says that it's improper for a judge to look to that. In fact, if anything, this court and the Supreme Court and other circuit courts of appeals have said that judges have very broad discretion in considering different factors, particularly if they're engaging.
You have posited two potential scenarios. I'm trying to understand how you know which one occurred here, given Judge Leon's lack of explanation.
Okay, I think we know it wasn't the former because he doesn't impose a 15-year sentence or say, I think the guidelines range should have been 180 months. And that's what I'm imposing here. That would have gone up to the line of saying, and perhaps crossed it, of saying, Winstead just doesn't apply. Remember, pre-Winstead, it would have been 180 months guidelines sentence. That because it was a career offender.
So the only way, in your view, for him to have signaled that he was not rejecting Winstead would have been to actually select the career offender sentence. There's no world in your view that he could have appreciated and understood the allegedly improper argument that the DC Circuit was wrong in Winstead. You don't think he could have taken that into account?
Again, I think we should. I think this court has always, applied a presumption that which could be rebutted, but there's a presumption that district judges know and apply the law. So I think there is certainly there's nothing in this record that rebuts that presumption, that the district judge was well aware of this court's decision in Winstead, understood that the career offender enhancement did not apply under the guidelines. And the court does not say, I think his real guidelines range was 180 months. And if anything, what I'm doing now is doing a downward variance. It's very clear. He's saying, look, I understand it's a 60-month guidelines. That's the guideline.
Can I clarify? Isn't 180 months ACCA, the ACCA, and not career offender? You keep saying 180.
So I think though with the career offender sentence, it would have been, and again, I apologize if I'm getting this a little bit wrong. Yes, an ACCA sentence, if the government had charged him as a career offender, if that had been in the indictment, then yes, the mandatory minimum sentence would have been 15 years. I believe the career offender enhancement, I can't remember exactly how much it was, but it would have been a lot higher. It would have been substantially higher. And the government did cite both of those aspects. It said, look, in Maryland, he could have been charged under ACCA. In other words, where the mandatory minimum sentence would have been 15 years because of the Fourth Circuit's approach. But then you also had this career offender enhancement that would have greatly increased the guidelines range. We know that Judge Leon did not, treat this guideline, his guideline sentence as being affected by the career offender enhancement. The only discussion that happened here was what kind of an upward variance should be applied. That's what the parties were arguing about, and the court settles this dispute. But it's very clear from the record why he does that. Again, I don't. This is, I think, very similar to what happened in United States versus Jackson, which we cite in our brief.
But
where,
Mr. Coleman,
Yes, sir.
Kigbay, Brown, and In re Sealed case were all plain error cases. And they're all cases that we reversed or we vacated and remanded for resentencing because of the failure to adequately explain the reasons.
Right.
And if you look at the explanations that were given in the Kigbay, Brown, and In re Sealed case, all of them seem to be more detailed explanations than what was given here. And yet we sent all of those back. So if we want to follow our own precedent, why wouldn't we send this one back?
All right. So I think there are some important distinctions between those cases and this one. If I could start with In re Sealed case, and I just want to make sure that I'm talking about the right one here. This is 527 F3rd 188. Is that the one that your honor is referring to? Okay. Appellate doesn't cite that here, but what I can say is this. In that case, which obviously involved the revocation of supervised release, the guidelines range is 3 to 9 months. The court imposes 18 months, even after the government had recommended only 12 months as a revocation sentence. The defendant there, although he had violated his supervised release, there was a pretty substantial dispute about that, and the violations themselves were certainly not the most serious. They involved a failure to communicate with the probation officer. They were not new offenses. So part of the problem was that there was, and this court clearly implies that there was a problem because this court couldn't really evaluate the substantive reasonableness of the sentence, which was apparently, in this court's view, in question without a greater statement of reasons. That isn't what I mean here. I don't think that there really is, any serious question that this was a substantively reasonable sentence for appellant, given his criminal history, given the severity of the offense here, where it's not just one gun, but he's got 6 guns and a lot of other stuff, given his conduct while pending sentencing, in which he doesn't just, fail to comply with Department of Corrections regulations, but he stabs another inmate. In light of those factors, I don't think any serious argument can be made that this isn't a substantively reasonable sentence, or that it isn't clear from the record why the district court varied upwards. So that's why I think this is a very different case from In re Sealed case.
So can I
In
just
Brown,
ask you, oh yes, go ahead.
Yes,
I'm
sir.
sorry, keep going. Mhm.
So in Brown, I think the bigger problem in Brown was that the court was essentially citing aspects of the defendant's offense and saying that it was more severe, when in fact those aspects were really just part of the offense. That's obviously, that involved child sexual abuse. So again, there wasn't the same clarity under the record as here as to why it was a much more serious offense than the ordinary mine run of offenses. This is beyond most 924C offenses, certainly that I've seen. And I'm sorry, Judge Jackson.
I guess I'm just trying to understand. So your point, I think, is that as long as the record is sufficient to support the substantive reasonableness of the unexplained sentence, there really isn't plain error, prejudice, or whatever. And that the distinction between this case and the others is that in those cases, there could be some question about what the sentence was, but in this case, there's not. Is that your point?
I think here, where the substantive reasonableness of the sentence is so clear, and it really isn't in doubt what factors the court was looking to, that a remand is really just pointless. There isn't anything that really needs to be said as to why the court varied upward in the way that it did.
Can I just ask you, Mr. Coleman?
Yes, Your Honor.
You keep saying it's so clear, and what's confusing to me about that is, first of all, we had the part one, to some extent, of the sentencing hearing in May. He imposed a sentence in September. Between that time, lots of things happened, including the probation office giving a recommendation, the sentencing in the guilty plea, I guess, or the sentencing in the other case. The parties have supplemental briefing. There's a lot of talk about the Fourth Circuit and Winstead and the other case and what its role is. So to me, as I see this record, there are lots of possibilities as to what the district court relied on in reaching 110. It's not like there really is only one factor at play, and so the 110 is plain on the record. And so I'm just concerned about your representation that this case is such that we can, anybody with eyes can look at it and see where 110 comes from, because I don't see that in this record.
So I have two responses, Your Honor. The first is, again, this is a plain error case. I think to hold sort of that any time a judge fails to give, a sufficiently, fulsome explanation at the time of sentencing that, satisfies all parties as to the sentence that the judge comes up to say that that's essentially just per se plain error that must be reversed. I don't think, first of all, it's not consistent with this court's decisions, because obviously this court did not reverse in Jackson. But I think it also sort of, absolves defense counsel of any obligation to say at the time of sentencing, look, I don't think the court has addressed every factor. I don't think the court, could you please explain to me why this happened, so that we don't just have seriatim reversals or remands for the court to, over the course potentially of months, if not years, provide an explanation. If the defense wants more of an explanation, it can get one. But secondly, I think the point is that if there are potential serious errors of law or mistakes of fact that could have been at play, or where it could well be that the substantive reasonableness of the sentence may be in question, and this court doesn't want to step in and just automatically say that's a substantively unreasonable sentence before giving the district court a chance to sort of step in and say that. If you don't have that, and we submit you don't have that on this record, then there isn't a need to remand. There is nothing more that needs to be said, because there is absolutely no, we submit there is nothing in this record to suggest that Judge Leon misapplied the law, refused to follow this court's teachings, that he misapplied the law, that he did not understand the facts correctly. I understand, of course, that appellant makes arguments now that the court didn't adequately consider things about his background. But the fact is, this is a defendant with a very serious criminal history, with a very serious offense at issue, and who had committed one of the more serious infractions that you can commit while pending sentencing. And in light of that record, we respectfully submit there just isn't a need. Certainly, he hasn't shown the possibility of prejudice that would justify a remand for him essentially to make further arguments to the district judge about his sentence.
Mr. Coleman, suppose we had a case where the maximum sentence was 5 years, and the guidelines range was 24 to 30 months, and the defense asks for 12 months, and the government asks for 48 months, and the court imposes a guideline sentence of 30 months and gives no explanation, just says I'm imposing a guideline sentence. I think that's fair and reasonable, and that's all the explanation. Under your view of the law, on plain error review, we would say that that's okay, right? Because it's clear that that's a substantively reasonable sentence, because it's a guideline sentence. Even if there's no explanation for why the district court didn't go below, very downward, as the defense wanted him to, or didn't vary upwards as the government wanted to, right? There would be no plain error if a guideline sentence were imposed and there is no explanation. That's the rule under your view of the law.
That is not our position, that that's just a hard and fast rule, because again, I think what we would need to know in Your Honor's hypothetical case is, for example, what were the reasons that the defense came up with for a below guideline sentence? Did he identify some factor that he thought the guidelines did not address, some aspect of the case? And if he could convince this court that the district court's failure to address that seriously called into question whether or not the sentence should have been the way that it was, or if he came to this court and said, look, there's a reason why the guidelines just would have been substantively unreasonable in my case, here's that factor, then perhaps he could establish plain error.
Coleman, are you aware of any instance where we have said that a guideline sentence is substantively unreasonable?
I don't think I can identify that offhand, but again, I'm not going to rule out the possibility that the defendant could at least make that argument. Whether he could make that showing, I don't know.
So, Mr. Coleman, don't we have here the exact flip side of what you are now saying? You suggest that if a defendant in Judge Wilkins' hypothetical could argue that the guideline sentence, there was some reason why it was substantively unreasonable, and the judge didn't address that maybe we'd have a plain error problem. It's possible. I see this as exactly the same, in the sense that the prosecution in this case said the guideline sentence we think is not sufficient for many reasons, among them that if he were prosecuted in the Fourth Circuit, you would give him career offender, the DC Circuit got it wrong, et cetera, right? So it's the same argument. He's saying the guideline sentence is not enough, Your Honor, and he goes on at length as to why that is. And then ultimately, the district court sentences above the guidelines. So why isn't that Judge Wilkins' hypothetical exactly with respect to the failure to explain for plain error purposes?
Well, I think the main difference is that that's why we aren't appellants here. We aren't here arguing that there was plain error committed essentially not in our favor by failing to give an even higher sentence than the one that the district court gave.
Oh, I understand. I'm just trying to isolate the error. Was from the court's perspective, regardless of who brings the argument, the question is, when the district court is presented with an argument that's essentially the guideline sentence is insufficient for X reason. You say if it's the defense saying it's insufficient, it's too much, you should give me a lower sentence, and the district court doesn't explain why he refuses to do that, then we might have a plain error problem. And I'm positing if, as here, someone made an argument that the guideline sentence is not sufficient, you should give a higher sentence, and the district court does do that. First of all, can't we assume that he relied on all of the factors that were presented, including perhaps an inappropriate one, the Winstead, et cetera? But even if we can't, why isn't the district court charged with prejudicial plain error to the extent that he doesn't explain why he was, whether he was motivated by that argument or not?
Well, right. I think it matters. First of all, that's why the prejudice component of plain error is so important. The party asserting plain error has to show how it substantially prejudiced that party. And I don't think appellant has made anywhere close to that kind of a showing in this case. If all of the factors are pushing the sentence above, if all the factors that have been seriously identified are ones that merit, that basically essentially say this should be a sentence above the guidelines range, and the district court was very clear in May that the whole point was this is going to go above that, then the fact that there may have been, the fact that the district court didn't go as far as perhaps the factors should have said, again, if the party that quote unquote prejudices in that case, which it would have to be the government, doesn't say this prejudices me, and so it's a plain error, so please reverse. If the party isn't doing that, then this court doesn't have reason to do that. But here, of course, the claimant is appellant.
So Judge Wilkins is correct that ultimately it reduces to whether or not the sentence imposed is substantively reasonable. Because every time you answer these questions, it comes back to, as long as we believe that Judge Wilkins hit a substantively reasonable number, then the party can't claim prejudice from him not explaining.
I think it's going to be very hard to do, particularly in the case, and if I could just compare this perhaps to the concept of when a defendant brings a claim of plain error at trial, okay, and says, okay, I didn't object to this aspect, some evidence that came in, or I didn't object to an instruction that was given at trial, but I think it was erroneous. I think it affected my trial. I think it's an error. It's plain and obvious here. He still is going to have to show prejudice. And if the evidence against him was overwhelming at trial, if the evidence of guilt was overwhelming, that is one major factor that this court would take into consideration in deciding whether substantial prejudice had been shown. And I think it applies again when the question is, ultimately, is this sentence substantively reasonable? Did the procedures somehow, was there some procedural error that either affected the substantive reasonableness or made it impossible for this court to determine that? But if it is very clear on the record that the sentence was substantively reasonable, at least from the point of view, ultimately, of the defense, in the sense that you don't really have any complaint to say that the sentence should have been a lot lower. And we submit that he hasn't shown that here.
Isn't there prejudice both in the hamstringing effective appellate review, because we don't have the reasons, and in undermining the appearance of fairness? When the law says you have to explain at sentencing district court, and the district court doesn't do that, isn't there some prejudicial effect on not only the defendant, but also the process?
So I think, again, the prejudice, Olano is pretty clear. The third prong, the prejudice has to be against the party. It's not just prejudiced against someone somewhere. And that's why there's a difference between the third prong and the fourth prong. The fourth prong, I understand, Your Honor. What one could make the argument that anytime a court sort of doesn't fully carry out statutory commands or make some error of law, that it has some effect on the public perception of
what about the defendant's perception? It doesn't. So your point is that it does not prejudice criminal defendants when they are sentenced without an explanation to them.
I think they have to show substantial prejudice, as Olano says. And although in the sentencing context, the showing of prejudice, isn't as great as in the trial, but I still think a defendant has to really articulate and convince this court that there was substantial prejudice against his interests. I don't think appellant has made that showing in this case. Right. I realize that I've greatly exceeded my time. I wasn't, if the court had any questions about appellant's ineffectiveness claim, I would be happy to introduce to answer those. Can I just ask you
one question? Your entire argument with respect to that seems to hinge on whether or not the sentence was delayed. But it seemed to me that the district court was really concerned about the plea, that it was the fact that Mr. Harrison pled guilty to the conduct in Superior Court that was really the linchpin. So hypothetically, if the defendant's argument was there was ineffective assistance of counsel because the counsel in Superior Court did not delay the plea, which happened after the district court case, would your argument be different?
Again, I'm not sure how different it would be, if only because it's not, given that he pleaded guilty and that again, I don't have the record of that case in front of this court here, but given that it doesn't seem that appellant really had a serious claim that he was innocent of the stabbing.
I understand, but the question is how much
and
did
he
it
admitted
matter?
to it.
Right, but it looked to me from the way the facts developed that Judge Leon was aware of that case initially, but didn't put off the sentencing because it was outstanding, it was pending, the defendant had not pled guilty, so he was going forward. Is that right, wrong?
No, that's not my understanding. If you
I
look at
see.
the May hearing, I think by the time of the May hearing, he'd already pleaded guilty.
Right, that's
You
my
know,
point. That's my
right.
point. Was it ineffective for the Superior Court counsel to allow him to plead guilty while there was a pending case in district court where the judge, could be concerned about the guilty plea?
So appellant certainly hasn't made that showing here. I mean, that isn't, it's been very hard to understand precisely what his claim is. As far as I can tell, following his reply brief, he seems to have pinned down the idea that he was subjected to consecutive sentences. In other words, that because the district court was allowed to sentence second, the district court ensured that the sentence in this case would be consecutive to the 90 days that he got in Superior Court. I don't think that, and before that, to the extent it was hard for me to tell from his opening brief if what he was saying is that it somehow increased his criminal history score, which didn't, because he hadn't, again, it didn't get calculated as part of his criminal history score. The fact that he did commit the stabbing, that happened the moment that he did it. And, the court was going to be aware of that by the government.
Yes, but judges, when they sentence, don't do so in light of pending allegations. They do so in light of established convictions in other jurisdictions. And so my question
I'm not entirely sure that's always the case. It certainly, Judge Leon would not have abused his discretion, even if appellant hadn't formally pled guilty, let's say by September. And instead you had the allegations and the government had come in and said, he stabbed another inmate. And appellant essentially just remained silent and said, like, well, those are just allegations. But then the government came in and said, look, here's the evidence, Your Honor. Here's what shows that he in fact committed the stabbing. And if Judge Leon had decided, certainly he only really has to do so by a preponderance for purposes of sentencing at most. But if he'd looked at those allegations and said, look, this looks very serious to me. You haven't really denied this. And, I think the evidence is overwhelming that you did stab another inmate. I don't think it's an abuse of discretion for him to take that into consideration. But again, appellant hasn't really identified what it was for, he hasn't even really identified a specific attorney that should have been, that was ineffective here, whether it was district court counsel for allowing sentencing to be delayed, or whether it was Superior Court counsel for not delaying further the plea or the sentencing. I mean, he's focused mostly on the sentencing. He has not really said that the plea. He has not, as far as I can tell, articulated that on appeal.
Counsel, I'm sorry,
I've
kept you over quite a bit. I just have one final, Judge Wilkins, with your permission, one final question, which is, there was something in the defendant's brief about knowing and voluntary and the extent to which the plea itself in this case was problematic. And in looking at the record, it's pretty clear that not all of the Rule 11 requirements in terms of the district court colloquy was followed. And I know in previous cases, the DC Circuit has admonished the U.S. Attorney's Office to make sure that they have practices and policies in place to assist the district court. And I'm just wondering about the status of that. Is there training on this in the U.S. Attorney's Office? What is going on with that?
We have endeavored to do so. It is sometimes a little difficult. Here, the Judge Leon did address the appeal waiver, which is the only thing at issue in the Rule 11 colloquy. And again, that's just ancillary as to whether he can even get this court to review that particular claim. And obviously, for the reasons we cite in the brief, we don't think it has substantive merit, even if this court were to reach it on plain error review. But as to the appeal waiver itself.
Sorry, he said appeal as to sentence. not appeal as to conviction, right? I mean, he did the appeal waiver.
Well, no, it's both. It's the appeal waiver as written. If you look at the written, it says he is giving up his right to appeal his conviction or his sentence, or to challenge in the collateral attack, except for ineffectiveness ground.
As written, but
The problem is that the judge. Go ahead, Jordan.
The judge did not break that out, correct, in his colloquy.
So, well, no. So the judge says what the judge specifically addresses and says, look, the only thing you're going to get to appeal is if the sentence here goes above the maximum by law. You are correct, Your Honor, that the judge doesn't address one specific clause of the written plea, the appeal waiver, which says you cannot challenge. You cannot raise a claim that your conduct does not fit within the scope of the statute. Okay. It would have certainly have been preferable under this court's case law for the judge to have expressly mentioned that. As for the training, I can say that for prosecutors, we have certainly tried to ask them to make sure that all aspects of an appeal waiver are mentioned orally at the Rule 11 colloquy. I think that training is ongoing. That's my understanding. And so, but there are going to be cases, unfortunately, where sometimes perhaps the prosecutor doesn't realize that the judge hasn't mentioned all aspects. And I think it is difficult for district judges, as other judges of this court have noted, to try to walk the fine line between summarizing an appeal waiver provision in a way that the layperson can understand, or just reading it verbatim, which may not be very helpful anyway. And so I think, that's still an ongoing process as to figure out sort of how to walk that line. This court, I think ultimately, even if this court decides that, perhaps it doesn't want to enforce the appeal waiver on that point, for the reasons we describe in our brief, there just isn't any substantive merit to appellant's claim that he didn't commit a 924C offense, because a felony punishable under the Controlled Substances Act includes carrying a weapon in connection with a narcotics conspiracy. If there are no further questions, we would respectfully submit that the judgment of the district court should be affirmed. Thank you.
All right. Thank you, Mr. Coleman. Mr. Orenberg will give you 2 minutes for rebuttal.
Thank you, Judge Wilkins. I think Judge Jackson hit the nail on the head when she said in a couple of different ways that Judge Leon did not tell us what he relied upon when sentencing Mr. Harrison in this case. Traditionally in a sentencing in this district and in the District of Maryland where I practice, a district court judge will go through the 18 U.S. Code 3553A factors, each of the 7 factors, and explain or describe under each of those 7 factors why he's going to impose the sentence that he or she eventually imposes. That did not happen in this case, and that has left us in a very uncomfortable posture. I think this court, at least Judge Jackson, has some concerns about the way that the district court conducted itself with respect to sentencing procedures. We don't know how he arrived at the 110-month final decision as to a sentence for Mr. Harrison. There's just speculation that it was halfway between this point and that point. That's all we have is speculation. We do not have an enumeration of the factors under 3553A or the specificity as required by 3553C2. Unless the court has any other questions, I will submit on the briefs.
All right. Thank you, counsel. We will take the matter under advisement.
Case number 20-5378, Telematch Inc. Appellant versus United States Department of Agriculture. Mr. Romano for the appellant, Mr. Walker for the appellee.
Morning, Mr. Romano. We'll hear from you.
Good morning, and may it please the court. My name is Anand Ramana, and I am I'm counsel for the appellant Telematch. From 2009 to 2019, the Department of Agriculture routinely granted Telematch's annual FOIA requests for spreadsheet data about agricultural programs. That consistent 10-year practice stopped in 2019. The law did not change, the requests did not change, and even the department's own FOIA guidance did not change. The only thing that changed was the person in charge of processing Telematch's FOIA requests. The government now maintains that it had it wrong all of those years. It defends its decision to withhold entire spreadsheets of government data on the grounds that exemptions 3 and 6 of the FOIA prohibit it from disclosing just 3 data points contained in those spreadsheets. It claims that exemption 3 bars farm and tract numbers that it creates and assigns to farmland. But exemption 3 does not apply because those labels, and they're just labels, are not geospatial information about agricultural land or operations. The government also argues that exemption 6 prohibits it from releasing the customer numbers contained in those spreadsheets. Customer numbers are numbers that it creates and assigns to the farmers that participate in the programs. But exemption 6 only protects things like medical records or personnel records that contain highly sensitive personal information. And in any event, release of the databases serves an important public purpose. Simply stated, neither FOIA exemption applies in this case. Moving to farm and tract numbers first. They're simply not geospatial information about agricultural land or operations. Now, exemption 3 of the FOIA, of course, prohibits the release of matters that are specifically exempted from disclosure by statute. And we don't dispute that there is a non-disclosure statute in this case. That non-disclosure statute is in Title VII of the United States Code, Section 8791B2B. And there it says that the department shall not disclose any geospatial information about agricultural land or operations. So the question isn't whether there is a non-disclosure statute. The question is whether farm and tract numbers fall within the boundaries of this statute.
I want to ask you a question about that because you concede in your brief at pages 52 and 53 that farm numbers and tract numbers, quote, can be tied to a specific physical location, end quote, right?
That's correct. They can be.
Then why isn't that dispositive that these are geospatial, that it's geospatial information? Because the common definition of geospatial in any dictionary is information that relates to a geographical location or a particular location. So if it's that simple, then I don't understand what the controversy is here about farm numbers and tract numbers being geospatial information.
Well, it's not that simple, Judge Wilkins, and a number of responses to that. What's important for the court is to determine the legal meaning of geospatial information about agricultural land and operations. Now, the district court is, as you point out, relied solely on common usage dictionaries. And that can be helpful when there is no other legal meaning in the law. But it shouldn't have been used in the first instance, and it certainly should not have been used exclusively here. The United States Code has several sections that define geospatial information or geospatial data.
Apply to Title VII. I mean, why are we looking to other parts of the U.S. Code and definitions from those when those weren't incorporated by Congress here? I mean, Congress knows how to say geospatial information here in this title means the same thing as it does in Title 13 or Section so-and-so.
There are a number of canons of statutory interpretation that are in play here, and Your Honor raises one, which is that true in the 1996 law and the 2018 law, it says geospatial data or information as used in this section. But there are other canons of statutory interpretation that are also in play here. In peri materia, which means if Congress has defined something about a very specific matter, and in this case it's geospatial information, then we can look throughout the code to see what Congress has meant in the past. And what Congress meant in the past in 1996 is a much more narrow definition than what the district court concluded here. It was not just any data that can be tied to land. It was data that was necessarily about the characteristics of the land or the location of the land. And so what we have here is we flip what your Honor's statement was. If Congress wanted to make the definition different for the purposes of 8791, that is when Congress should have said, we have a definition that's been on the books for almost 20 years. Can
you tell me a case where we have held, or the Supreme Court has held, that if Congress defines a term in a particular manner in a completely different title of the U.S. Code, we presume that they mean the same thing in a separate title of U.S. Code when they use that same term?
I don't, Your Honor, have an authority on that, but the canons of statutory interpretation, I don't have it before me, though, that are in play are in peri materia, which is the canon of statutory interpretation that says if Congress has previously decided to define a term specifically in a very specific and technical manner previously, that will be imported into the subsequent statute unless Congress has decided to expand or limit the definition as it was created before. Otherwise, it's otherwise known as the presumption of
materia applies to sections like all within the same title, subtitle, that basically relate to each other because they're all about the same they're all part of the same, statutory scheme that's at issue, right? Don't use materia to say, oh, in Title 7, they must mean the same thing that they said in Title 18.
Well, I don't necessarily agree with that, simply because the two statutes that are in play govern geospatial information. The 1996 statute was the statute that created the National Geospatial Intelligence Agency. It defines geospatial information in a limited manner. The 2018 Act that I refer to is the Geospatial Data Act. And the government, even in its papers, has conceded that act actually applies to their analysis. So while maybe organizationally it was not placed in Title VII because it was the Farm Bill, it was part of a Farm Bill, an omnibus bill, it wasn't placed in Title VII. The subject matter is exactly the same. It's about geospatial information.
Mr. Romano, what are the definitions in that other statute that you'd like us to take a look at, and why do you keep saying that they're more narrow?
They're more narrow. So in the 1996 law, which is 10 USC 467 subsection 4, and I'll quote it, the term geospatial information means information that identifies the geographic location and characteristics of natural or constructed features and boundaries. So the district court, and there's a similar, I'll read the Geospatial Data Act. It says that geospatial data is information that is tied to a location on this earth, including by identifying the geographic location and characteristics of natural and constructed features and boundaries. So the district court's common usage definition was broad. It just said any data that can be associated with a particular plot of land, any data. In these legal definitions, not the common usage definitions, but in these legal definitions, it's more narrow because it's data associated with the land, but that data has to be about the characteristics of the land, the height, whether there's water, or the location or the boundaries of the land.
That's not even what the statute says. You're talking about 43 USC 2801, right?
For the Geospatial Data Act of 2018.
The term geospatial data, that's what you just read, right?
That's right. Means the information that is tied to a location on the earth, that's the portion that the government cites. But it then goes on to say,
and it says including by, but that doesn't mean that. And when you say including, it doesn't mean that it has to also identify that. It says,
Yeah,
it says, you know, it could say including but not limited to.
It could be read that way, Your Honor.
But including doesn't mean that it has to have everything that follows after including. That's giving one example of information that is tied to a location on the earth.
It could be read that way, Your Honor, and I agree with that. But what we have are two legal definitions that call out.
And reading it that way would be consistent with the common usage in dictionary definitions, right?
Well, but yes, but then what you have is basically an unspoken indefinite definition. And we know that in the context of Exemption 3, this court as early as 1987 has said that Exemption 3 non-disclosure statutes must be read narrowly. And that's from the Association of Retired Railroad Workers versus the Railroad.
Mr. Romana, I asked you about the definition that you want to apply because I still am struggling to see why that doesn't apply here. We have a situation, my understanding is that the USDA took maps, actual maps, which I think you concede, the aerial maps themselves are geospatial data, no?
Oh, we concede that the maps themselves with the data on them would be, yes, that's correct.
Right, so the maps they took, they drew boundaries. They drew boundaries that corresponded to the edges of farms, to tracks within the farms. There are polygons on this map, I understand, and they numbered those. All right. So I don't understand why that doesn't fit even within the definition that you are putting forward. We have boundaries. We have boundaries that relate to locations on a map that you concede counts as a geospatial font of information.
Your Honor, if we were asking for those maps and those polygons, then I would agree that 8791B2B applies. But that's not what we've asked for in the request. In fact, we withdrew that request after the multi-ag media after the Farm Bill was passed.
I understand. You're asking for a list of the numbers, but those numbers were derived from and relate to the polygons on the map. So why isn't geospatial information, even as you've defined it, broad enough to encompass that? It's not numbers that had never had any relationship to a map or never had any relationship to location, right? They're only there because the USDA used a map, numbered the polygons, and then created a list. So what I don't understand is how that doesn't qualify because it relates to the list that exists.
So in a FOIA request, we're only analyzing the requested records and whether those records fall within the non-disclosure statute. If you look at a farm number or a track number, ABC, XYZ, that data, because that's the only data that we're asking for. We're not asking for the maps. We don't think we're entitled to them. We're not asking for the polygons.
Let me give you a hypothetical. You don't think the maps count because I hear you conceding that they qualify as geospatial data.
Yes.
Am I right about that?
That's right. That is correct.
In my hypothetical, we have a map that some agency has drawn, circles, squares, whatnot. And then there's a legend, and the legend happens to be on the second page. And it says, the squares are this location on the earth, the circles are this location, whatever. Just because you don't ask for the map, but you're seeking the legend, doesn't seem to me that means the second page is not geospatial data. You're making the argument that just because we're asking for the list that tells us what's going on in the map, we're outside of the realm of the excludable under this statute.
I am making that argument, Your Honor, that the first page of the map would be properly withheld, but the second would not because it's not inherently geospatial. Another, I guess, counter hypothetical to that would be we all have driver's license. It says brown eyes on mine. It has all of your eye color on your licenses. Somewhere there's a government database that could theoretically put together a map of where all the brown-eyed people live in say Fairfax County, all the blue-eyed people, and you could have a map. Are we now to say that the driver's license that has brown eyes and blue eyes on it because those eyes,
Yes,
whoever
you've done
lives
it
at
the
those,
opposite. You've done it the opposite, right? My
Right.
hypothetical posits that the data comes from the map, and that makes all the difference. It's one thing to have a data set that exists independently and that we make a map out of it. And then maybe you say, oh, that data existed, all the driver's licenses were somewhere already. And so the fact that someone made a map doesn't turn that into geospatial. I'm saying the opposite, that we start with the map is the thing, and we've made now a list of the features of the map. And for you to suggest that those features, just because they're on a list somewhere, aren't geospatial doesn't seem to make a lot of sense to me.
well, I would respectfully dispute the fact that the map comes first. You know, this is a little bit of a chicken and the egg, but farm and tract numbers can be divided, transferred. They can move from plot to plot over time, and they often do. When there is a transfer if one farmer has a plot of land and they buy their neighbor's farmer, the middle boundary goes away and one of the farm numbers goes away and it expands. So these are fungible. These are fungible labels. They're not about the land themselves. These are labels that the government uses. So while that map remains static, while that aerial photograph remains static because it is about the land, or the boundaries that you can see on it are about the land, those labels can be modified, they can be moved, they can be eliminated, new ones can be created. It's not about the land. It's an administrative tool of convenience to label these agricultural plots of land. It's not about the characteristics. It's not about the location of the land. And in fact, a farm number can change. It's the land to which it is assigned. The farm number can move to a different plot of land, and the characteristic, farm number ABC number 123 is transferred down the road. Then there are different characteristics of that land. That's not to say that land characteristics change. It's to say that the label changed. So
you want a code, which, as I understand it, is nothing but a pointer to some specific plot of land. Is that not right?
Do I want it's not to a, well,
the code is just USDA shorthand for whatever, Farmer Jones plot at 7 degrees north and 10 degrees west. That's what that
correct. It is, but it is meaningless in terms of geolocating or geospatial if you don't have the 7 degrees north or the location or the map. So the reason it's important to our client, though, is its combination with farm numbers and those other types of mathematical cover.
It's important to your client precisely because you can use other stuff to figure out, to break the code and figure out that XYZ really means Farmer Jones plot.
Well, there's actually nothing in the record that discusses farm and tract numbers, and the government obviously has the burden to prove Exemption 3 status. I see that I'm already far over my time and haven't gotten to Exemption 6.
We'll give you some more time because I do want to hear from you about the Exemption 6 argument. But it seems like your response to Judge Katsas's question is like saying, well, if we request social security numbers of all of the applicants, that's not really personal information, because if they just give us social security numbers without the names, we won't know whose social security numbers we're getting. We'll just have a list of social security numbers. But that doesn't change the fact that a social security number is personal information, does it?
I think that the analogy to social security numbers fails because social security numbers are tied to any number of privacy type information. The customer numbers are used within a closed universe, a universe that we don't have access to, other than the spreadsheets that we've received for 10 years in a row. And so it isn't tied to individual data. You could take I can't do this, but hackers can take a social security number and tie that to other personal information. And in the Exemption 6 analysis,
Wait, before you
there is
switch to that, can I just ask you really quickly?
Oh.
What about addresses? Addresses, geospatial or not?
No, they're not geospatial because they are, and a good example is they're just labels of property. When you have an address, if you looked at 101 Cottage Street, you wouldn't know where that was. So what do? You type it into your phone. Your phone converts that using geospatial data, and then it provides you with a geospatial record of where it is. But the address by itself is simply a label. That label can be, a plot can be divided, and 101 Cottage Street can turn into 101 and 103 Cottage Street, or they could rename the street. It's just a label, and a label, just a label, a naming label is not geospatial. It's not about the characteristics of the land or the location of the land. So no, I don't think, and the government incidentally agrees with that because
it's not, and excuse me, it's not information about geospatial, something geospatial.
Exactly.
That's your thing. Why
That's
is that?
exactly
Why is it not information about geospatial something?
Because it's not information about characteristics of the land or the location of the land. And the government agrees with this because one of the files that's responsive to our request is called the names and addresses file. And it identifies all of the residential addresses. They never have asserted Exemption 3 status over addresses, over residential addresses. Now, we were the ones that identified a potential problem, not under Exemption 3, but with Exemption 6, although we don't think that there is one. But if the government thought that farm and tract numbers were geospatial, then you would easily think that they would have concluded the same about names and addresses.
Isn't there a requirement? Don't they have to give that information under some other statute?
Which yes, they have to give names, addresses, and payment information, but not names and addresses by themselves. And
Okay,
so,
what about Exemption 6? I'm sorry to take you back to 3.
That's okay, Your Honor. So, well, I'm trying to think back to Judge Wilkins' question, but the customer numbers is not like Social Security number, because a Social Security number, in an Exemption 6 analysis, we can look to derivative uses. What can someone do with this information once they look at it? The burden is very high, though, to prove that there is a derivative use. The government has to prove that there's a substantial probability that disclosure will cause interference with personal privacy. Government hasn't done that at all, hasn't explained it all with any level of detail. But even if we go back, and we're back off of the customer number itself, Exemption 6 only applies to medical records, to personnel records, or something like that. So you think of a FOIA request for DOJ personnel files. Exemption 6 prohibits that, the disclosure of those personnel files, or medical files.
This court has precedents that indicate it can be a bit of information. It doesn't have to be a whole file.
That's correct. That's correct. And a good example of that is someone wants to get a Medicare or Medicaid payment to pay for their medical costs. You don't have to send the whole medical file over. You can send a bit of information. But these are big government created administrative spreadsheets. That's not what Exemption 6 is intended to cover. It's not government administrative files. And to the contrary, FOIA specifically targets these types of government spreadsheets, because that is exactly the purpose of FOIA, is so that you can ask to see what the government is up to. Well, there's no better way to see what the government is up to than to look at its administrative files, these files that they create in their course of governing, in their course of business, that demonstrate where the payments are going, what land is being conserved, how long is it being conserved? Is it being conserved the way it was supposed to be? Are families splitting up so that they can receive subsidy caps beyond the statutory limit? So with the Exemption 6 analysis, there are really just two main points. One, these aren't the types of files that Congress intended to protect. They're not personnel files, they're not medical files, or even personnel or medical type highly sensitive information. Most of these farmers don't even know what their customer numbers are. They input it in if they have to log into the USDA websites, but it's not personal information. And to the extent that And even the district court agreed that customer numbers disclose nothing about an individual farmer to the public, including the farmer's identity.
Do you dispute that the customer numbers can be used to identify farmers personally when combined with other publicly available information?
I do dispute it only because I haven't seen an argument or any type of evidence in the government's papers in the district court or here that raises the substantial probability that there is interference with the privacy interest.
No. I'm asking a different question. I thought that we had declarations that indicated that a customer number could be used in conjunction with other publicly available information to identify farmers. So we do have some evidence about that. And my question is, do you dispute that that's the case? And if so, where is your evidence that these customer numbers cannot be used in that way?
So I don't dispute that there is a declaration that says that if you use some type of federal or state requirement records somewhere, that there could be some type of privacy interest. But we don't know there's no evidence, no affidavit evidence or no exemplary evidence of what those state records are, federal records are, no evidence of how they could be used, no evidence about how they can infringe on a privacy interest. And that certainly does not it does not satisfy the very high burden of substantial probability that personal privacy could be threatened, especially when none of the records that we have can combine customer numbers with
counsel
individuals' names.
We have procedures in summary judgment for a reason. And at JA 277, we have the government statement of undisputed fact. Paragraph 30 says that existing publicly available data can be connected with information from these FOIA requests, including the customer number, to form a comprehensive picture of these businesses. Think that fact is true, and here's our counter affidavit. But you didn't do that, did you?
No, we did not.
So to accept the record as it is, that paragraph 30 is established for summary judgment purposes, right?
We can, yes, that is correct. That the way that this is drafted is undisputed in our case.
So doesn't that answer Judge Jackson's question about what the state of the evidence is here, in that there is evidence in the record that's undisputed that the customer number can be linked with publicly available data to form a comprehensive picture of these individual small businesses are, right?
So the statement here is established for purposes of summary judgment, but it's still the government's burden to satisfy to prove that there is a substantial probability of a threatened privacy right. And this, even if established, doesn't even come close to meeting that standard. So even if you look at the amount of evidence, it's just scant evidence, vague evidence, really no examples at all. Had the government put in an example of you take X record and you combine it with Y record, and this is the privacy record that interest that's revealed, and this is a problem because of.
So Mr. Romano, you seem to be rejecting page 287 in the Declaration of Philip Buchanan, paragraphs 11, 12, 13, where he goes into examples of the manner in which the farm and tract numbers may be combined with other publicly available data to specifically identify a farm or tract, and the extent to which that is problematic for a particular farmer. You're saying
again,
that's not sufficient?
I am saying it's not sufficient, that even though in the declaration itself, there are some other vague references to, well, if you just use the internet, you could figure this out. That's not sufficient to satisfy the substantial probability of a privacy interest being threatened. Whose privacy interest? There's no name. How is there a privacy interest even involved when you can't link a customer number to a name? Whose privacy interest is threatened? We don't know. And so if there's no way to know that citizen ABC XYZ, we maybe it's good to say, well, we could threaten the privacy interest of that particular number, but we have no idea who in the country that is. So there's certainly no substantial probability that privacy concerns will be threatened in this case. So it's insufficient evidence to satisfy the very high burden that the government has on Exemption 6.
Are you telling me that when we read this declaration in pages 287 and 288 that Judge Jackson referred to, that's not saying that people can identify a person associated with a farm or tract number or a customer ID? You're saying that this affidavit isn't telling us that?
I'm saying that the affidavit says what it says. I'm saying that is an insufficient amount of evidence by far to satisfy the very high burden that the government has to prove that there is a substantial probability that a privacy right will be threatened, or that there'll be a revelation of some sort of, sensitive private.
Isn't that the whole reason why you are seeking this information? I mean, why your client is seeking data and information, these numbers that USCA has, precisely because my understanding was you want to try to identify the farms, figure out whether or not people are improperly being subsidized, figure out. So you have to know who the people are in order to do that, right? You say we want to know what the government is up to, but the way in which you know what the government is up to in the way that you're talking about is you identify who the people are who are getting these monies, who are putting in the applications, and you then determine whether the government is doing what it's supposed to do. So I don't know how you can have it both ways, right?
Well, so I think I have an answer for that. No, we're not intending to be, or the argument isn't, we'd like to be the private attorney general here. The idea is that we can determine statistically, one way or another, what are the compliance rates? You don't need the individual names for that. How many, if there are 10,000 customer numbers out there, how many of those customer numbers are receiving subsidies in excess of the statutory caps? It's more of a snapshot on the efficiency of the program, whether there is fraud, waste, and abuse in the program. It's not, hey, we think we've nailed Farmer Jones over here because we've now linked this to the individual names. It is more of a public oversight argument where you don't need, and nor do we want, the individual names at all in this. It's the customer numbers as a percentage, say, of customer numbers, how many of them are abusing the system. Of the farm, and just one correction there too, though, farm and tract numbers are not part of the Exemption 6 analysis. So we put those aside. Those are just under the Exemption 3 analysis. So we look at also compliance rates. How many customers are complying with the conservation requirements? If their land is in conservation for 10 years, that land is transferred to a different customer number because they sold it. Does that landowner all of a sudden in year 4 turn it into soybeans? Well, that would be a violation of the conservation rule. It's not about identifying specific individuals in violation of certain rules. It's the aggregate, maybe statistical type review of that. The public and that's what the public monitoring aspect of it is. It is divorced from the individual names and addresses.
Can I ask you a question about a statutory interpretation question? So
yes.
Talking about Exemption 3, you were looking at the limitation on disclosures at 7 USC 8791,
right,
sub B, and in the limitations are in sub B, 2A and B, and the geospatial information limitation is in B. But in 2A, it says that the secretary is not supposed to disclose information that is provided, essentially, the way I read this, by a farmer in order to participate in the programs of the department.
Correct.
Isn't that an articulation by Congress, whether we agree that it's good policy or not? You know, we can debate that, but ultimately Congress sets policy, we don't. Isn't that an articulation by Congress specifically that they don't intend to have disclosed information that these applicants for subsidies give to the government in order to participate in the program? And shouldn't that, even though, you know, we're dealing with Exemption 6, which is this balancing, but shouldn't this prohibition and kind of Congress's view about non-disclosure of information that's provided by farmers to participate in the program, shouldn't that weigh in how we balance the public interest versus the privacy interest?
If I understand your argument or your question, Your Honor, it is you're still referring to customer numbers here.
Yes.
And even though we are analyzing customer numbers under Exemption 6, Your Honor is suggesting, well, shouldn't we still look to this non-disclosure statute, subsection B2A, to help inform the Exemption 6 analysis?
Yes.
So maybe not surprisingly, my answer is no, it doesn't, because customer numbers, and the reason the government hasn't argued this is customer numbers do not fall within subsection B2A. The government admits this on Joint Appendix 275, paragraph 22. They admit that the numbers are not submitted by farmers, the customer numbers. Now, remember, we're just talking about the customer numbers here.
But I guess what the government does say is that you can use the customer numbers to link to other information that that would give you kind of information that tells you the financial picture of a particular farm, right?
Well, yes, I think we have to be very careful about this derivative use argument, because if we start looking to who the requester is and what the requester does with the information, then instead of the government adjudicating a FOIA request by looking at the records that are being requested, which is the proper analysis, they start adjudicating the requesters themselves. And you have a couple of different problems. You obviously have the potential for discriminatory conduct, but say we're a for-profit company. Say you have a watchdog agency that asks for the exact same records. We don't get it because they think, well, you have the ability or the opportunity to link it with other things, and all of this other information would be unlocked. But the watchdog agency, the government says, well, you're the good guys, we'll give it to you. What's to say that that information won't be sold by the good guys to anybody else? So I think we have to be very, very careful, and that's why there's such a high burden for the government, substantial probability to invade a private right or privacy information. We have to be very careful about derivative use, because you start adjudicating the requesters. And as a practical matter, I think that really just takes away the whole idea that FOIA is about looking to the government records to determine whether the records themselves are releasable to show the world what the government is up to.
All
so
right.
I'm sorry.
But thank you for you've answered my question. Judge Katsas, do you have any questions? Judge Jackson?
Nothing else.
All right, we'll
Thank
give
you.
a couple of minutes on rebuttal. Let's
Thank
hear
you.
from Mr. Walker.
Thank you, Your Honor. May it please the court. My name is Johnny Walker. I'm representing the Department of Agriculture. I would like to start with the topic under discussion just now about whether or not customer numbers can be linked to particular individuals. Now, what my friend on the other side says is that the government has not presented sufficient evidence in our declarations to show that to be true because it lacks any examples. We disagree with that, but that is not all we have relied on. If the court will refer its attention to page 109 of the joint appendix, this is a declaration put into the record by the plaintiff, by Telematch. And in paragraph 59 of that declaration, they represent to be in possession of what they refer to as a name and address file. And what you'll see from that file is that it contains names, addresses, zip codes linked to a customer number. This is something they have, something they've put into the record, and they know full well that there is information in the public domain in their possession that links customer numbers to specific individuals. And so the problem that we have is that what this case is essentially a redux of multi-ag media. You have essentially the same requester seeking essentially the same information about farms and farming practices from the USDA. Now, in multi-ag media, this court conducted an Exemption 6 balancing analysis and determined that the USDA must release to the requester information about farming operations that is tied to specific farmers and farms. But critically, what happened right after multi-ag media in response to that case is the United States Congress passed a statute, section 8791B, that's of critical importance in this case. And what that statute says is it essentially undertakes the Exemption 6 balancing for itself. And it says that the USDA may continue to release payment information that is tied to specific names and addresses. And in this case, the USDA did release that information to Telematch, but it is prohibited from releasing two types of information. One is geospatial information, and the other is information about agricultural land, operations, or conservation practices, unless, and there is an exception, and this is the exception that matters, because what my friend would like to pretend is that the information that's being protected by that statute are the numbers themselves, and because those are not submitted by the farms and farmers, that they don't fall under the statute. But the statute does prohibit us from releasing the substantive information about farming practices unless that information is anonymized. That is, that it is released, quote, without naming any individual, owner, operator, or producer, or specific data gathering site. Because the customer numbers would name specific owners, operators, and producers, and because the farm and tract numbers would name specific farms and tracts, the USDA is compelled to withhold that information when it releases the substantive farm information. And I'd also like to correct a misstatement that my friend made during his opening, which is that the USDA withheld the full spreadsheets because they contain that information, and that is not the case. In the denial letters that are all within the record here, what the USDA said to Telematch is that it could have all of the substantive farm information that is in the USDA's files, but it would have to withhold only those three numbers in releasing that information. And it may be the case that Telematch did not take the USDA up on that offer, but the USDA did not withhold the full spreadsheets with one exception, and that is the spreadsheet containing only names, addresses, and customer identification numbers. I'd also like to address one of the issues that was raised in the briefs in the appellant's reply brief. Now, we relied on this case Central Platte for the proposition that I believe it was the Eighth Circuit upheld the denial of farm and tract numbers in that case. And in appellant's reply, they make the argument that in that case, the appellant requested the farm and tract numbers tied to individual images. There's actually nothing of the sort stated in either the district court opinion or the Court of Appeals opinion in that case. What the district court opinion makes clear is that the requester sought farm and tract numbers from the database that contains the images, but not necessarily the images itself. That's exactly what Telematch is seeking here. They want the farm and tract numbers connected with all of the substantive farms and tracts that are connected with all the substantive farm data that is also in the records that they request, so that they can tie all that information back to specific farms. But again, 8791's anonymizing requirement compels the USDA to withhold that information and make sure that those farms and tracts cannot be identified because they are data gathering sites.
Can you help me understand why you're calling this an anonymizing requirement? The 8791B4 begins with nothing in this subsection affects the disclosure of information if the information has been transformed, I'm in B now, into a statistical or aggregate form without naming any. So I guess I'm trying to wrap my mind around the language in relation to your argument that this is some kind of requirement to not release personally identifying information.
Sure, Your Honor. It doesn't actually relate directly to our geospatial argument. Our geospatial argument is simply that when this court reads an undefined term in a statute like this, it uses the ordinary meaning. Not a highly technical meaning derived from Wikipedia articles, not meanings that are specific to other statutes and applications, the ordinary meaning. And we have 3 dictionary definitions to show that the ordinary meanings support our reading. So geospatial is somewhat, our argument about the geospatial information is aside from this disclosure exception. Where this comes into play is the argument that we made in the district court that has not been developed in this court, that the farm and tract information, the farm and tract numbers are independently withheld as a result of this condition on disclosure, because the government can only release the substantive farm information if it withholds information that would name the specific data gathering site, which the farm and tract numbers do.
If that argument was not really raised here, then isn't it waived in some way? Like I'm struggling.
It's not waived by us, Your Honor. The district court did not address it, and appellant did not raise it in their opening appeal. In their opening brief, we mentioned it in our brief simply to note that if the court were to rule against us on the geospatial argument, then it would have to remand to the district court as its usual practice to consider that argument. The court could consider it if it pleased for the first time in the appeal. But because neither appellant argued about it in the opening brief, and because the district court did not address it, the normal practice would be to remand to address it in the district court in the first instance.
All right.
And the way that the disclosure exemption relates to our Exemption 6 argument is, as I said, this statute is essentially a rebalancing of the public and private interest factors by Congress following this court's decision in multi-ag media. And so when plaintiff makes an argument that it needs the customer numbers tied to the farm data so that it can engage in these compliance and monitoring activities, our argument is simply that's what multi-ag media found, but the landscape is very different now because we only release this information in a fully anonymized form. And plaintiff does not say that they can conduct any sort of monitoring activities with the data in a fully anonymized form. And to the extent that they can, it has been offered to them. The USDA said that they would provide all of this data without the customer numbers that would name the specific customers, as the USDA has shown, and as plaintiff has admitted in JA 109.
And I guess the question that I had of your friend on the other side is, shouldn't kind of the presence of this statute and how Congress altered the statutory scheme after multi-ag media, shouldn't that play a role in our Exemption 6 balancing analysis?
Yes, Your Honor, and I think the answer is exactly yes for the reasons that I mentioned. I mean, if you step back and look at the broader picture here, multi-ag media conducted the Exemption 6 analysis in the way that plaintiff suggests, and Congress within a year stepped in with a statute intended specifically to abrogate that result. And as a result of that statute, a different result is compelled. Like I say, the government is prohibited from releasing any of the substantive information about farming practices that plaintiff wants. And it's important to note that plaintiff does not say that the substantive information about farming practices, conservation practices, and the land itself that it is seeking would not invade on the privacy of an individual if tied to an individual. Their sole argument is that the customer number, release of the customer numbers in the abstract would not invade on the privacy of that individual because it doesn't identify an individual. That's wrong in 2 respects. Number 1 is that it can be tied to an individual and they have the list to do it. And number 2 is because they haven't just requested customer numbers in the abstract, they have requested customer numbers associated with the very type of substantive information about farming practices that they concede would invade on a person's personal privacy, and that the USDA is prohibited from associating together by Section 8791.
So is that argument about whether there is a privacy interest or whether in the balance any privacy interest outweighs their need for the information or the public's interest in the information?
It's really about the balancing, Your Honor, because I think they concede that there is a privacy interest in the farming practices here to the extent that they can be tied to an individual. They've never said otherwise. And indeed, the court in multi-ag media found that there was a substantial privacy interest. The balancing just came out the other way. And it's important to note one of the files requested here is exactly the same file that was requested in multi-ag media. And all of the information is about farming practices, the land itself, or conservation practices. So plaintiff puts up no argument that if we're able to tie the actual substantive information about agricultural operations to individuals, that would be a substantial invasion of personal privacy. And it clearly can be tied to individuals. So the question is then, how does the balancing come out? And because of this statute that was passed after multi-ag media with the specific intent to change the result of multi-ag media, that balancing comes out another way. All of the information that they would be able to get and that they have gotten is anonymized, and it shows only sort of the substantive information without any association to a particular customer. One other thing that I would like to get, I think my friend on the other side made an argument about that the USDA previously released addresses, and that if these farm and tract numbers are geospatial, then why weren't addresses geospatial? And it has to do with how this information was maintained. So the geospatial limitation under B2A, or I'm sorry, B2B, refers to geospatial information otherwise maintained by the Secretary about agricultural land or operations for which information described in subparagraph A is provided. Now that would be actual farms and tracts, farm and tract numbers designate. The addresses that are in the file that was released to plaintiff and that appears at 109 in the joint appendix, those are the addresses of individuals who received subsidy payments from the USDA. So there's not a total. Those addresses would not necessarily meet the other criteria of 2B, which is that they be about agricultural land or operations.
Can I just ask you back to the balancing point, because I'm really a little struggling with the language in multimedia, multi-ag that seems to indicate that there is a strong public interest in information that could help evaluate how well the agency is determining eligibility, policing noncompliance, et cetera. So do you dispute that there is any public interest in that, or are you just saying it's not been established the need for it here, or what is your response to that?
Yes, Your Honor. So I would say that there is some public interest there, but Congress has rebalanced it in a significant way. So in multi-ag media, what was requested and what the court ordered released was substantive information about farming practices that could be tied to farms and tracts and customers, tied to specific farms and farmers. And what Congress said following multi-ag media is, you know what, you can release information about farming operations, but only if it meets the conditions of B4, one of which is that the disclosure of information must be transformed in a way that does not name any individual owner, operator, or producer, and that does not name any specific data gathering site. So because of that, the balancing is now that requesters, there's an interest in getting anonymized data about farming operations, and that to the extent that monitoring can be done with that, it is releasable. But the sole argument that Telematch is making here, because what it wants to do is identify those customers.
But I feel
the sole argument it's making here is that
I feel like you're mixing exemptions, right? So to the extent that there is a statutory provision that prevents the government from releasing identifiable information in the way that you say, came after multimedia, fine. Why isn't that an exemption 3 argument? If we're in exemption 6 world, then I don't know that Congress's setting up the statute in the way that it did actually is responsive to my question about public interest. Isn't there a public interest in this information?
Well, like I say, the only public interest that Telematch has articulated is that it has a public interest and a need to have information about farm operations tied to customer numbers. And what we're saying is, if that's your argument, it fails under Exemption 6, because you can't get farming information about farming operations tied to specific customers, because the statute specifically prohibits us from releasing that, the Exemption 3 statute. So if you're going to make an Exemption 6 argument, there has to be another public interest at play here, and they have not articulated one, and that's because what they want are those customer numbers. The balance, like I say, that Congress has struck here is that we can release information, statistical information about farming practices, but not in a way that identifies the individual owner, operator, or producer. And Telematch can identify them. It has done so at JA 109. Unless the court has any further questions, we ask that you please affirm the district court.
All right, Judge Katsas,
I'm all set, thanks.
Judge Jackson.
I'm all right. Thank you.
All right, we'll hear from Mr. Romano. We'll give him 2 minutes for rebuttal.
Thank you, Judge Wilkins. Just a few points. Judge Wilkins, there's been some discussion here today about shouldn't we look at Exemption 3 to help us inform the Exemption 6 analysis, in particular whether there is a privacy interest or a public interest. And I hadn't thought about it until today, but looking at 8791, if the court is inclined to do that, then that bends in our favor as well, because while Your Honor was focusing on B2A, we also have, as Judge Jackson has identified, the very specific exception to all of this, which is that payment information and names and addresses must be released. So that is Congress saying this is not a privacy interest, and in fact, it's a public interest to make sure that we know what money is going to whom. And so we have, if we wanted to use 8791 to inform the Exemption 6 analysis, and I haven't really done the research on that, but if we wanted to do that, then the answer is actually the names and addresses and payments should be released, and categorically that is not the type of privacy information that we want to protect, because Congress has said right here, no, you have to release it. So that's the public interest, and that should be what informs the Exemption 6 analysis. So that's the first point. The second point is going back to the common usage.
Sorry, could you just give me the site to what you just referred to? Is that B4 exception?
Yes, it is 7 USC 8791.
Right.
B4.
Okay.
A.
I have it. Thank you.
It doesn't affect the disclosure of payment information, including payment information and the names of addresses of recipients. That's Congress saying that's a public interest. You have to release it. And so that should inform Exemption 6. Just quickly on the common usage, my colleague said that these are consistent definitions. No, that's part of the problem with using the common usage definitions, is that the two definitions relied upon by the district court are very widely in scope. The first one is just relating to data associated with a location, which is the one it adopted. But the second one says relating to geographic data, often resulting in computer visualizations, and that's narrow. So that's why I suggest that instead of using starting at the common usage and maybe to the exclusion, why don't we look to how this term was defined by Congress in 1996 and then redefined in 2018.
Mr. Romano, before your time goes out, can I just direct you back to the other issue about public interest and
yes,
ask you to comment on consumer checkbook, which seemed to suggest that you don't get information that has some privacy implications just to do a sort of free-ranging evaluation of government operations, that there have to be some indication that there's actual mismanagement or fraud or something in order for the balance to come out in your way. So can you comment on that?
Sure. I think generally speaking, that case kind of stands for the proposition of you can't be the investigator for the government. You're not in the AG's office. You're not the FBI. That case is distinguishable in my view, though, because that case was about, first and foremost, it was Exemption 6 type documents. They were medical files, like the type I referred to earlier, medical or personnel files. These are medical files. These are files, or at least medical information, health information that's being submitted to the government for payment. And so you actually get over step one here, which isn't the case in here, where we have these massive databases of administrative data.
All right, so you're saying the privacy interests were greater in that case. I understand. What I'm asking,
absolutely,
what I'm asking is about the public interest. They seem to suggest that a public interest that is unsupported by some indication of mismanagement or fraud, if the public's interest is just, I want to look at what the government is doing, there has to be more than that in order to make that a cognizable public interest for the purpose of this balance.
Right.
Why isn't that applicable to what we're doing here?
I think if you look to the multi-ag media case, it explains why that fraud, waste, and abuse is obviously prevalent in agricultural programs, or all government payment programs in general, and also compliance rates. There are public interests that have previously been identified in that and other cases, though, as well. And so while I took the district court's opinion to mean, well, we have to actually present evidence so that we can make this argument, almost like a standing argument, I think we've got to be careful, because it's a little circular. We have this evidence of fraud, so let's see how much fraud there is. I think that's a little circular. But two, we get into that derivative use issue again, where now we're going to, and you heard it from counsel, well, this is what they're doing. This is what they're doing with the information. Then you're going to start discriminating amongst requesters, and that's not what the FOIA is intended to do. It's intended to look at the documents themselves, look at the information in that documents themselves, and with a blind eye to the world, say, yes, that is releasable, or it is not releasable. And in this case, the farm and track numbers don't fall within Exemption 3, and the customer's numbers, there's been no showing of substantial probability that there's a privacy interest. And those public interests have been articulated in other case law, which is why you find them in our briefs as well. Your Honor, if there's no other questions, we ask that this court reverse the judgment and require the United States Department of Agriculture to return to its former practice of disclosing in its entirety.
All right, thank you. We'll take the matter under advisement, and we'll take a 5-minute recess before calling the next case.
Thank you, Your Honors.
This honorable court will now take a brief recess. Judges, if you could please give me a minute while I put everybody in the waiting room. The attorneys to start their videos. And I'm telling IT that we can begin to broadcast again. I have one attorney whose video is not turned on. Mr. Hughes, I have sent you, oh, perfect. This honorable court is again in session. Case number 19-1224 et al. Belmont Municipal Light Department et al. Petitioners versus Federal Energy Regulatory Commission. Mr. Coyle for the petitioner, New England Consumer-Owned Systems. Mr. Aslin for the state petitioners. Ms. Roberts for the petitioners, Sierra Club and Union of Concerned Scientists. Mr. Kennedy for the respondent, FERC. Mr. Hughes for the respondent interveners, New England Owner Generators Association et al.
All right. Mr. Coyle, we'll hear from you.
Good morning, Your Honors. May it please the court, I am John Coyle, firm Duncan and Allen LLP, on behalf of petitioners Belmont Municipal Light Department et al. Call ourselves the New England Consumer-Owned Systems here, and Energy New England LLC. I've reserved 4 minutes of time for rebuttal. With my co-petitioners counsel, we'd like to invite the court to direct questions on rebuttal anywhere they like. But unless you specify you want to hear an answer from Ms. Roberts or Mr. Aslin, I'll be the default rebuttal counsel. The order on review in this case is based not on substantial evidence or reasoned decision-making, but on speculation and sloganeering. There are 4 fatal flaws in this order. It is unsupported by substantial evidence or reasoned decision-making. There is no calibration of the incentive provided by the $82.49 per megawatt hour forward price or the $8.25 per megawatt hour real-time adder for so-called inventoried energy. No calibration of that incentive to need, and the rate itself is neither cost-based nor market-based. Therefore, has no inherent guarantee of justness or reasonableness. Third, the decision unreasonably, it is unreasonable to accept payments, to accept ISO New England's proposal for payments to resources that will not respond to the incentive. These are resources that naturally inventory energy and indeed have no choice. Coal-fired power plants, nuclear plants, or certain hydroelectric plants that inevitably store fuel or other energy sources and will not increase their ability to do that in response to the incentive provided by the rate in the inventoried energy program. And finally,
why is it unreasonable to provide compensation for the value provided by energy stability? And those resources are, on the one hand, they're at a major disadvantage because they're more expensive. On the other hand, they provide this distinct benefit, which is the energy is there, it's stored, and it can be used in a pinch. So if you compensate for that value, you would tend to make those resources better able to compete, and you might save the marginal ones from going under. And we know that New England has this major energy problem caused in part by a lot of these older kinds of technologies going under.
it's an interesting hypothesis, Your Honor. Unfortunately, there's no evidence in the record or no analysis in the record to support it. And the point of the rate that's been established in this case is to elicit additional supplies of energy during the winter months, not
there's no evidence to support the calibration, or there's no evidence to support just the basic reasoning that I gave you, which is let's compensate for elements of value so that people contributing to security appropriately get compensated and won't have to fold when they shouldn't.
Uh, there was no evidence adduced to relate the payment to the value of that allegedly stored energy, number one. Number two, as your honor knows.
Yeah, I understand, but that's an argument really for the whole thing. That's not distinct to the coal producers.
True. There was also, your honor, a prior determination by the commission not to pay these kinds of resources because they're not in a position to respond to the incentive. Now, FERC tried to get around that in its decision in this case. I'm referring, by the way, to prior decisions in ISO New England Inc. 152 FERC, paragraph 61-190 at paragraph 47, and the order denying rehearing in that case, 154 FERC, paragraph 61-133 at paragraph 13. And the basis for the commission's denial in that instance is there is no supplemental response from these resources in response to the supplemental payment. Now, FERC attempted to get around that in its decision here by rebranding the product, okay, as inventoried energy rather than under the prior decision, it was winter reliability. In substance, it was inventoried oil. But the use of a semantic dodge to, in essence, rebrand the product so that more people could get paid doesn't constitute reasoned decision making.
Didn't he also, Mr. Cole, have another plan happening to address the potential retirements? I mean, I understand Judge Katsas is sort of saying, well, we want to make sure these people are happy because they might drop out or they might retire, but I'd understood there was some other way to prevent that.
Sorry, Your Honor, I didn't mean to step on your question. Yeah, there are, that's kind of the fourth problem with the order is there is a forward capacity market in New England. And FERC did not evaluate the impact of its acceptance of the inventoried energy program here on the operation of other markets. In particular, the forward capacity market is intended to incentivize the orderly retirement of uneconomic units and their replacement by newer and more efficient generation. And by propping up units that have become uneconomic with this additional compensation, the inventoried energy program dampens the price signal that the forward capacity market is intended to send. There is also a pay for performance program, which is intended to incentivize generators to maintain fuel on site when they have a capacity supply obligation under the market rules so that they can produce energy on call. And again, this our view was that this inventoried energy program interferes with the price signals sent by the other market mechanism, the pay for performance mechanism. And FERC didn't evaluate it. It simply said, oh, they're complementary because they both incent the same thing. It's not true. They actually work to some extent at cross purposes because the inventoried energy program payment to some extent offsets the incentive that the penalty structure and pay for performance is intended to create. Did that cover your question, Your Honor?
I believe so. I think I was more focused on the cost of service plan and the extent to which that addressed the problem that it seemed as though Judge Katsas was focusing on.
And that's and that again is a different flaw in the order that FERC relies on ISO New England's January 2018 operational fuel security analysis as having created some sense of exigency about bringing in more energy supply. But by the time FERC had allowed the inventoried energy program to become effective, FERC had also accepted a cost of service agreement that would keep 1,500 megawatts of liquefied natural gas fired combined cycle capacity in service, the Mystic 8 and 9 units, And so to the extent that I think what Your Honor is referring to is that specifically, which is not addressed really at all in the Commission's reliance on the operational fuel security analysis, but also a generic rule change accepted along with the Mystic 8 and 9 agreement that allowed the ISO New England to retain retiring units on a cost of service basis if they were needed for fuel security. You're referring to one or two of those? Or
yes, yes. I think the latter, but yes.
Okay.
Yes.
All right. Yeah. So there were many other paths that were already in place, and again, there's no analysis of whether the incremental payment associated with the inventoried energy program is necessary or sufficient, or how much additional supply do we need? How much is this additional payment likely to elicit? Really no analysis of how this incremental payment is likely to influence the retirement decisions of existing generators, because there was ample evidence on this record that the incremental payment would amount best case to approximately 50 cents a kilowatt month, which is within the play of forward capacity auction prices, and for a 2-year interval was unlikely to influence any retirement decision. And indeed, NEPCA, New England Power Generators Association, the intervener you'll be hearing from a little later, had a great metaphor for it. They said it's like two people working on a road crew where one's filling the pothole and the other guy's taking the fill out of the pothole. At the end of the day, you still have a pothole. This is, again, the sort of the analytical deficiencies of the proposed program. There was no exigency behind this program either. The only exigency that actually involved is ISO New England's unilateral commitment undertaken in another case, really, to put before the Commission a more market-based means of securing winter supplemental winter fuel than its previous essentially either cost-based or auction-based procurement of additional oil supplies in the winter.
Mr. Cole, can you speak? Oh, sorry, Judge Katsas, go ahead.
Are you saying no exigency because you don't think that the macro problem is real?
No.
Or no exigency because you think that the pay for performance program addresses the misaligned incentives problem and the what's the other one? The cost of service program addresses the issue I was addressing, which is suppliers that might be marginally beneficial, taking into account the security value, are going to fold.
If Your Honor will indulge me, I'd like to unpack your question a little bit.
Sure.
On a macro level, sure, there is a problem. And I think for then Commissioner Glick, now Chairman Glick, discussed that very well
pretty compellingly
in his dissent. That while you need to address the problem, you don't address the problem by creating a system where, for all the evidence shows, the customers would be better off if you burned the money to generate electricity.
Well, but you may cut the agency a little bit more slack to the extent you think that there is a real problem. Everyone seems to think if you get to the point of rolling blackouts,
right,
those costs are going to dwarf any cost we're talking about here.
Yep.
We're only talking about 2 years. They were bumping up against the bidding deadlines for the 23 futures.
Yep.
Why shouldn't we cut them a little bit of slack if we think, you know, they're in the right ballpark, but they didn't calibrate it perfectly?
Well, if I could finish unpacking your first question, all right, that's fine. But I have answers to all those.
Go ahead.
The commission relies, and NEPCA helps them rely on the notion that there is some urgency to coming up with a resolution to the problem that justifies bypassing principles of sound market design, right? Because we know ISO New England admitted in their response to FERC administrative staff's deficiency letter, that's record item 71, that there were a lot of analyses they didn't do. ISO New England didn't do. They didn't identify the amount of inventoried energy needed to maintain system reliability. That's JA 515. They didn't quantify the benefits expected from the inventoried energy program. They didn't evaluate the cost impacts, including opportunity costs and energy market offers. And they didn't evaluate whether or not the IEP would have ensured reliability under past winters. And they didn't evaluate whether or not the IEP was actually capable of reducing generator entitlements. That's why I say you have an order here that is largely based on speculation and sloganeering, not on the kind of analysis that would support the hypotheses that are being advanced as, in essence, rank speculation here. There's no evidence to support those hypotheses at this point in the case. There should have been. If you wanted to support this program as just and reasonable under Section 205 of the Federal Power Act, there should have been evidence. There is very little, if any. An administratively determined price, a single price, is, as Chairman Blake said, not a market of any kind. It is simply an incentive bonus and spread around to resources that really are not in a position to respond to. So I thank you.
Judge Katsas, does that answer your question?
Yes, thank you.
Over your time, I just want to see if Judge Katsas or Judge Jackson have any other questions for this petition.
No, I'm all set. Thank you.
Thank you.
All right, we'll give you some time on rebuttal. Let's hear from counsel for, I believe it's the state petitioners.
Thank you, Your Honor. May it please the court, Christopher Aslan on behalf of the state petitioners. I think there's 3 points I'd like to make briefly for the court to focus the attention here, and they relate to the 2 primary justifications that FERC gave for approval of the IEP program. And the first point is that this so-called misaligned incentives problem that Judge Katsas was referring to earlier really only applies to natural gas and oil resources. It does not apply to other resources such as nuclear, coal, biomass, and hydroelectric resources. And therefore, it is not a reasonable justification for inclusion of those other resources in this program and paying them money. The second point is that with regard to those other resources, nuclear, coal, hydroelectric, and biomass, the justification was that this program may in some way help deter retirement of some of those resources. However, as Attorney Coyle pointed out, there simply was no record evidence to support that notion other than anecdotal theory that, well, if you give them more money, they might do better. But we don't have analysis to show how much money is enough. And in fact, the record has contrary evidence that the commission did not respond to. And then the third point is that without these justifications being supported in the record, you're left with a program that saddles consumers with up to 5 times the cost of prior winter reliability programs, which is clearly excessive. It's serving the same basic role as these prior programs, but charging a significant greater amount of money to consumers. So I'm happy to unpack any of those. I'll start with the misaligned incentives piece. The ISO New England relies on this problem, misaligned incentive problem, based on a discussion paper that's part of the record. That paper, discussion paper, clearly, and it appears in the joint appendix at page 731 for your reference. That discussion paper clearly focuses in on resources, natural gas primarily, but also oil resources that have production uncertainty, which the discussion paper discusses as meaning that they typically don't achieve awards in the day-ahead market. In other words, they know that they're likely to have the fuel they need and be able to produce that energy at the time that's needed. That does not apply to nuclear, biomass, coal, or hydroelectric resources typically. And indeed, some, as a discussion paper points out, some highly efficient natural gas resources are also in the day-ahead market, and this misaligned incentive problem doesn't really apply to them either. And so without that problem relating to the resources that ISO New England is trying to include in this program, you're simply, as Commissioner Glick pointed out, you're simply putting money in for no particular benefit to customers. That's the first point. The second point.
Can I, Mr. Aslan, before you
Yes.
leave that point, I always try to think about things relative to our role, burden, oversight, and under the statutes, and what FERC's responsibility was when evaluating this IEP. So the defect that you've now identified, to the extent that the plan was not tailored adequately to address misaligned incentives because it applied to these entities to whom that is not an issue. What is the nature of that problem? Is it that there wasn't evidence? Is it arbitrariness? Is that where we are? Or are you suggesting that it's a sort of a substantive problem? Do you understand my question? I'm sorry, it wasn't
I do, yes.
articulate as it could have been. Okay.
Yeah, that's clear. Yeah, I believe that the fundamental problem is it goes to the just and reasonableness of the right, because what in effect, if you are paying resources for no particular benefit to customers, that is definitionally an excessive rate and therefore not just and reasonable. There's also an arbitrary factor here in the sense that I believe Mr. Quayle already pointed out, the FERC has previously made a determination that those resources, nuclear, coal, et cetera, should not be part of winter reliability programs for that same reason, because they are not incentivized to procure additional fuel resources or supply agreements. They already do that as a matter of course under the market system that they operate in today. And so,
but they did acknowledge that change. So to the extent that they changed position, isn't there information in the record that indicates that FERC recognized that they had previously held a different view on this?
they did, Your Honor, but they didn't provide a reasoned explanation for the change in course, other than to say that this will help the misaligned incentives problem. However, as I pointed out, that misaligned incentive problem is not relevant to these additional resources. Paying nuclear more money will not change a misaligned incentive because they're not subject to a misaligned incentives problem to begin with. And so to the extent that they acknowledged their change, of course, they didn't provide a reasoned decision for that change, and then I would argue it's an arbitrary decision. And then we have the bigger problem on the retirement side of the equation, which is that there simply isn't substantial evidence to show that we will achieve any of the benefits that are potential, that have been raised by ISO New England as a possibility, where we might deter the retirement of some resource that provides these secured energy benefits. We don't have that evidence in the record, and there was evidence.
You have a history. You have a history of these other plants getting forced out of the market, right? Because they will lose the competitive bids with the natural gas plants, right? Which can supply energy more cheaply.
That's right. That is a problem.
But they provide this distinct benefit, which the market doesn't seem to value, which is the security.
I would agree with that, Your Honor, but this program, the IEP program, doesn't adequately address that problem in a targeted way. And there's two flaws. One, it doesn't set a price that's aimed at addressing that problem. And the price that it does set, there's no evidence that it would actually deter any retirements. And in fact, there was evidence in the record from an analyst for the Massachusetts Attorney General, Benjamin Griffiths, that he did an analysis to show that the amount of revenue that would come to these resources is so small in the context of the energy and capacity resources, the revenues that they obtain, that it's unlikely to have any effect on the retirement decisions, particularly when this is only a 2-year program. And you have large swings in energy and capacity prices from year to year that dwarf this change in revenue that you might get from this program. That evidence is in the protest of the Massachusetts Attorney General, and it appears in the joint appendix at pages 190 to 208. It wasn't addressed by the commission either.
And Mr. Aplin, isn't the retirement history that Judge Katsas is referring to before these other mitigating measures as well? I keep coming back to that because I'm trying to understand whether and to what extent FERC took into account that there were already other sort of intervening measures dealing with the retirement problem put into place.
I would agree, Your Honor, that the Pay for Performance program went into effect in 2019. It's just playing out now. We're starting to see it, what role it plays. But beyond some nominal lip service in the commission's order, say, we don't think that there's a problem here. They didn't provide any real analysis or explanation of how these programs would interact. And the same goes for the cost of service tariff that was approved that allows the ISO to retain resources that may retire under the market system if they're needed for reliability. That wasn't clearly addressed by the commission either.
On your argument is that, the rate is just, has to be just and reasonable and that the cost here is excessive. It seems that FERC's response is basically, look, there are benefits to this that you can't quantify because reliability of the grid is an important benefit that can be recognized, and you can't necessarily quantify that. And then secondly, if there are situations where there are blackouts or power losses, that can cost businesses, in the billions of dollars, and there's information in the record about that. And then thirdly, they talk about the differences in wholesale prices, I think, from a really, a bad winter in 2013 or 2012, I think it is, versus wholesale prices in 2016 or thereabouts, and there being a $1 billion difference in the wholesale prices where you had the kind of bad winter and the potential reliability problems. And so putting all those things together, FERC seems to be arguing, yeah, $300 million is we understand that's a big price tag, but when you look at everything in context, it's money well spent, given the, all of these different things. What's wrong with that argument?
Well, Your Honor, I think there are two problems with the argument. One, there's no doubt that there's this large risk factor out there. It's undefined to some extent, but it exists. The first problem is that this program, the IEP, we have no analysis to show that it will address that problem effectively. And in fact, we think it won't address that problem effectively. The second issue is the cost. As I mentioned earlier, ISO New England has had winter reliability programs in place over a number of years in the past decade at significantly lower costs. And so we have a problem for the FERC here to say, what's the justification for paying upwards to $150 million of consumer money for a program where the prior winter reliability programs came in around $30 million a year? That's a huge change without any analysis to suggest that we are actually going to receive substantially more benefit, either in reliability or eliminating high price spikes in the markets. We just don't have any analysis in this record to show that that is a justified expense, and therefore we argue that it's excessive and that there's a lack of substantial evidence.
What evidence do you point to in the record that the reliability problems that FERC is concerned about in those two winters coming up, beginning, I guess, winter of 2024, that there won't be any reliability problems during those two winters?
Well, we can't say that there won't be a reliability problem, and that is a problem that exists. However, it's ISO New England as the proponent and FERC as the adjudicator or the regulator to determine whether this particular program addresses those needs appropriately. If we just say, well, there's a big problem coming, let's throw as much money as possible at it and hope for the best, that's essentially where we are in this case.
But it seems to me that what you're arguing is that everything that we have is really sufficient, or we don't need, to spend all this money on this particular program. But you're saying that without pointing me to any evidence that the status quo is working.
Sure. So the alternative here, Your Honor, would be to reintroduce a program like the former winter reliability programs, which were significantly cheaper. And though every winter is different, they met the need, and they did incentivize resources to retain additional fuel sources for the winter periods. We haven't seen any evidence that that would not be sufficient going forward. There's just the operational fuel security assessment was done in 2018, I believe. It says under these certain assumptions, we see that there's going to be a problem. But those assumptions are just assumptions. And that is really the only evidence in the record here that there will be a problem. I think we can all agree that there are these concerns, but we don't know the extent of those concerns. And therefore we can't say that this program will adequately address them.
All right. I think in the interest of time, unless there's further questions from Judge Katsas or Judge Jackson, we'll move on.
Thank you.
Roberts.
Thank you. May it please the court, Casey Roberts on behalf of environmental petitioners. The inventoried energy program could cost consumers more than $300 million over 2 years. So it's fair to ask that FERC rely upon substantial evidence of an urgent reliability problem before approving the admittedly substandard design of this program on grounds that there wasn't time to do a more thorough job. But the order on review fails to establish a near-term reliability problem not already addressed by ISO New England's existing rules. In a single sentence of its order, FERC passingly mentions the operational fuel security analysis and the findings in its 2018 order as justification for the program. FERC and NEPCA make a lot of this single sentence in their briefs, but in doing so draw from parts of the analysis that FERC never mentioned in either the July 2018 order or the one under review here. I think it's particularly important listening to some of the questions earlier to distinguish between what FERC has now said in its briefs to bolster the order below and what was actually in that order below, which is very, very little on the existence of an urgent problem. So the findings in that 2018 order were specific to the risks posed by the retirement of the Mystic units. And that makes sense because that was the question before the commission at the time. And then following that 2018 order, the commission approved a program to allow ISO New England to prevent the retirement of units as needed to ensure winter energy adequacy. Those are the cost of service agreements. And the ISO has used that authority to delay the retirement of the Mystic units for several years at significant cost to consumers. Notably, ISO New England recently decided that those units were no longer necessary for fuel security in the winter of 24-25, which would have belies the breathless takes otherwise that there's an imminent fuel security problem. In the order below, there's just a single order on review here. The commission never adequately explains why that authority that it gave ISO New England to prevent the retirement of units needed for fuel security is inadequate to address any imminent risk. It's touched upon very, very briefly in paragraph 117 of the commission's order, and the commission then simply refers back to this misaligned incentives theory, which, as Mr. Aslan explained, doesn't really connect to the retirement concern, which is mostly about generators who kind of don't suffer from the so-called misaligned incentives problem. And I'll note that in the December 2020 order, the commission concluded that the concerns it had expressed back in 2018 had actually been resolved by this retirement prevention cost of service program. And that's when the order in which FERC terminated the Section 206 proceeding. And ISO New England itself described the IEP, the Inventoried Energy Program, as being aimed at precisely the same problems identified by the commission in the 2018 proceeding. So essentially what we have here is FERC allowing ISO New England to sort of double dip on the findings in that 2018 proceeding, not only implement the cost of service provisions, but also implement another interim program without explaining why there's still some urgent problem that hasn't been addressed. So the second error in FERC's order that I want to discuss is the commission's complete failure to respond to environmental petitioners' argument that the program is unduly discriminatory. We argue the program discriminates by providing compensation to an arbitrary subset of resources that alleviate the region's dependency on just-in-time delivery of gas from the region's pipeline system. And as an example, we submitted evidence produced by IS in New England showing how offshore wind production reduces the drawdown on fuel supplies in the region during the cold snaps. But FERC responded only to a straw man version of our argument, arguing why wind and solar resources aren't similarly situated in their ability to provide inventoried energy. That wasn't our argument below. I can go into it if there's questions. But essentially, FERC did not meet its obligation to respond to legitimate objections.
Can you just summarize? So what is your discrimination argument?
Yeah, so our discrimination argument is that in defining this inventoried energy product as the solution to the broader alleged problem of winter energy adequacy in the region, FERC has created a product that only certain kinds of resources can be eligible for. Right, so the problem is too many resources relying on just-in-time deliveries from the pipeline system. Therefore, they're not able to generate electricity when it's needed, when there's also demand on that pipeline system from, for building uses, heating, that sort of thing. So renewable energy that alleviates the drawdown on the region's fuel supplies and that can generate, notwithstanding reliance on that pipeline system, those resources are similarly situated to resources that can inventory fuel in terms of their ability to help address the core problem.
So
but
it sort of seems to me like it's in the nature of a definition that you have a particular problem that you're trying to address, and it seems, you say it's broad, but it is these kinds of resources that are not going to be able to produce when called upon because the incentives are wrong. And by its definition, that doesn't apply to the kinds of resources that you're talking about because they're able to produce regardless. I don't know how that's necessarily discriminatory. It's that the problem doesn't encompass the groups that you're talking about. So of course the solution isn't addressed to them.
I hear what you're saying, except when the solution is money, that's incentives that are being paid to these other generators to help those generators fix a particular deficiency that they have in their ability to generate electricity, and then similar benefits are not available to other resource types, it's not an efficient or just and reasonable way of getting at the problem. I mean, FERC has actually acknowledged this sort of undue discrimination framework in some of its orders on the prior winter reliability programs, which Mr. Coyle was explaining earlier, and did require IS in New England in coming back with a revised winter reliability program to address whether it could be done in a way that was more fuel neutral, was sort of the term they used at the time. And if it couldn't be done in a more fuel neutral way, to explain why. So Judge Jackson, your questions, I think, are valid, and they're ones that FERC should have considered, but they didn't even address our undue discrimination argument. They pretended it was this much simpler argument about whether wind and solar could provide inventoried energy, which is a rather simple answer, but that was not our question. So we would like FERC to be considering this in the first instance, as it should under the APA.
All right, any other questions, Judge Katsas, Judge Jackson?
No, thank you.
All right, we'll hear from Mr. Kennedy for responding.
Good morning, Your Honors. Robert Kennedy on behalf of the Commission. Before touching on the specific points raised by petitioners in their objections to the program, I think it's important to step back, sort of as Judge Katsas did, and set the context here, which is important. In this case, the Commission was presented with forecasts indicating that from the system operator in New England, indicating that if there isn't a course correction, there's significant risk of energy shortfalls on the coldest days of the year. And as we just saw this winter in Texas, that can have tremendous public welfare impacts. The Commission was presented with a stopgap 2-year program to try and address that, kind of tide the market over until this flaw in the market that doesn't value fuel reliability can be permanently resolved. And it does it by compensating all resources who are able to provide the product that the system operator is looking for, inventoried energy. All units who are able to respond to the system operator's request to run on the coldest days of the year. And, the Commission acknowledges, ISO New England acknowledged when it made this proposal that it's certainly not perfect.
Can I ask you, assume I think the problem is real and that this would be a reasonable but though not perfect response in the absence of anything else. But why do you need this program on a semi-emergency basis where you have pay for performance, which addresses misaligned incentives? And if a penalty on pay for performance is too low to realign the incentives, the obvious solution would seem to be just raise the penalty. And then you have cost of service to address the distinct problem of the high cost, high secure providers who might otherwise go out of business. Why do you need this on top of those two?
So with respect to cost of service, if you go back to the Mystic Order, which is essentially incorporated in this order, in paragraph 55, the commission made its ultimate finding that not only does the region need these cost of service agreements, but there also needs to it needs to better improve its market design to better address the regional fuel security revisions. And it made that finding because, and this responds to some of the arguments we heard today, the misaligned incentive problem is at the heart of this, that natural gas generators, which on any given day, on normal days, are roughly 45, 50% of the region's generation needs. They don't have the financial incentive to enter into firm fuel delivery agreements because, as explained in the brief, as explained in the materials submitted by the system operator, that has an upfront cost, and the end result is it brings down the price of energy. And if you do all the probability analyses and the math, it's not worth it most of the time for the generators to do that. So just having these cost of service agreements wouldn't address that situation at all. And second, these cost of service agreements, just to give you some context here, they're massively expensive. I mean, we talked about the Mystic agreement. That's, I believe, in the neighborhood of 400 million for one unit, 2 years, one generating station in one area of the region. The commission has always reviewed these as sort of a tool of last resort. So the inventory energy program is a interim tool, so you don't have to resort to that too much. In fact, if you go back and look at these court's opinions in Connecticut Department of Public Utility and some of the other ones from the late 2000 timeframes, we have a capacity market in New England because there were so many cost of service agreements that were being used with these generators who were retiring that the stakeholders had to come up with a different solution. So that never
Mr. Kennedy, I'm struggling to understand why your response is actually responsive to Judge Katsas, because he pointed out two different programs.
Correct. And so
and to the extent that misaligned incentives is the problem, I'm wondering why entities that don't have that problem are being compensated in this way, and why the program that is directed, the other interim pay for performance or whatnot, why that is not sufficient to deal with your misaligned incentives problem.
Correct. Yeah. I was responding to the second half of Judge Katz's question to take your 2 points, which should address his as well. Why the eligibility question? Why are we including these resources who in the normal course of business have fuel on site during the coldest days of the year? And as what the system operator has done here, it has identified a market flaw that the market does not value this reliability attribute that they bring to the table. And
what does that mean? I admit I'm not economics expert.
Sure.
So the system does not value them, meaning they're not being paid enough to keep the fuel on site.
Correct. I mean, no, they do keep the fuel on site. But, all right. But
for the cost that we already have before your program, right?
Correct.
They keep the fuel on site. And isn't that the objective? We want them to keep the fuel on site?
Correct. The problem is the revenues they derive from ISO New England's other markets, energy market, its capacity market, its ancillary services, are insufficient to cover their costs. So they're going away. And just to signal why that's so important, and I believe this is in the fuel security analysis, there's an example in a typical day in typical month in New England. There was a cold snap, and I believe went over the end of December 2017 to early 2018. I believe coal was like 0.3% all of December until that 1 week when it was about 24% of the megawatts produced.
Right, but can I ask you a question? Are they going away based on evidence that you have looked at after the implementation of the cost for performance, after the implementation of the other interim measures that were supposed to keep them from going away? Do we have evidence related to that?
That the retirement studies have been updated since paper performance?
Yes.
I'm not sure when the projections date from. I know ISO New England put forward those numbers in the fuel security agreement and in this filing, which postdate the beginning of paper performance. And if you kind of look at the,
I'm sorry, does pay for performance apply to the coal and nuclear suppliers? I thought it was.
I believe it's everyone who has a capacity supply obligation.
Okay.
Now they're not duplicative. Paper performance either pays you or penalizes you for not providing energy during scarcity conditions. The inventory energy program compensates you for having this reliability attribute, being able to answer the.
I understand, but pay for performance should tend to help make the coal producers more viable because it's easy for them to make a capacity commitment and satisfy it.
Well, if you look at it does not. If you look at the discussion paper put forward by the ISO and this is around JA 749 through 751, it explains why the incentives, and it goes through various scarcity analyses, probability analyses, and explains why the incentives created by the paper performance problem haven't solved
that's directed
security,
that's directed to misaligned incentives, correct, which applies to the natural gas people. What I'm trying to understand, dovetailing with Judge Katsas' question, is to the extent that pay for performance does apply to biogas and those stored fuel capacity entities, and they get it, why doesn't that help to solve the problem of their going under?
Well, I think because the main pay performance largely is a stick. If you take on a commitment and you can't meet it, you get penalized.
But they can't meet it.
You get extra.
Right, but already the revenues that they're getting, this is a capacity, pay performance interacts with the capacity market. The revenues they're getting from that market and the energy market are insufficient to cover their costs and keep them going. At least that
they don't get more for
going
pay.
Forward.
I thought there was also a benefit if you can meet it under pay for performance.
Well, there's a baseline, you get a baseline capacity payment. And as my understanding of paper performance, if there's a scarcity condition, I'm not sure the number of times that comes up per year, but if you overproduce, yes, you can get some benefit. But I believe what the system operator says here is looking at the baseline, which includes paper performance, that the market still doesn't value these resources enough to cover their costs and have them there in the future when we need to call.
So what's your response to Mr. Coyle's point that even if that's true, even if we have some nebulous understanding of the market undervaluing these resources, there doesn't seem to be any analysis of how much more they need in order to prevent them from retirement, of the extent of the problem concerning their undervalue. There's like, I didn't see anything, and I think many of your opponents in their briefs pointed out this vacuum of analysis that would actually substantiate these contentions. So what do you say about that? Am I missing it?
So the system operator explained, just to respond to a point that's inherent in your question and that Counsel for New Hampshire raised, that the point is not that this is going to give them a revenue stream that's enough to cover the shortfall that currently exists, that will take them out of the risk for retirement. The point is this will allow them to lower their bids into the capacity market and obtain a capacity commitment for future years and get the revenue stream through that. System operator, yes, there is no there is no analysis of here's the 5,000 megawatts that are at risk for retirement. Here's how much they need. No, that is not in the record. What we have is a system operator identifying these resources being at risk and providing a proposal based on sound economic theory, and in their judgment, will incent these resources to stay in the market and delay the retirements for 2 years until the region can come together and deal with a long-term proposal. And part of the reason that they didn't go through that exercise and the commission found this reasonable is because this has been going on for a decade, trying to come up with a solution to this problem. And there's a myriad of factors as to why it is a problem and why it's so difficult.
I don't know if the longevity helps you or hurts you.
So the point
to me that if it's been going on for a decade, there should be some data about it, right? I mean, there should be some.
Well, there is data, Your Honor. If you look through the fuel security agreement, the retirement study I think was first done back in 2012, 2014. There was 8,100 megawatts at risk for retirement, and now we're down to 5,000. And the entire region is just 30,000. So that's a significant clip. So the forecasts have been coming true, unfortunately. And what changed here is in 2018, ISO New England went through this detailed analysis and found, hey, you know what? These things are really important. We need them on the coldest days of the year. And right now, the market's in flux and we don't have a ready available replacement. So we need to recognize the value they provide for the market and develop a way to keep them online. Why there was no detailed study before then is, the IO explained it would take some time. This program needed to be simple enough for generators to understand and in place before they made the retirement decisions, which are generally, if I'm doing the math right, 4 years in advance from when it happens. So that's part of the explanation is why there's not a full-blown study, but it's based on a reasonable theory put forward by the system, reasonable economic principles put forward by the system operator upon which the commission relied. Now, there's some suggestion in the brief, the capacity prices are coming down. That means this whole thing's a sham. Obviously, that's a benefit to consumers, but as the system operator explains, in ISO New England, they use a downward sloping demand curve. So as the price comes down, there's actually more capacity awards. And in the system operator's opinion, who runs these markets, that's an indication that fewer retirements will occur.
Can I ask you, Mr. Kennedy, does FERC give deference to the system operators in their analysis? Is there some kind of a thing that happens in FERC's own review of things that they sort of just defer to what the system operator wants?
No, I think as the commission said in this order, it held the system operator to the fact that this is an interim program doesn't mean they don't need to support it with substantial evidence, but these are the people running the markets. They are putting forward sworn testimony. Some of the forward rate and the determination as to what that should be to incent enough resources to participate was prepared by an outside consultant. So definitely there is some expertise there.
And wasn't there a point at which
does not give blind deference to this?
Wasn't there a point at which the system operator updated the data, updated the information? I think Ms. Roberts talked about it, that they actually said that we don't need as much because they're not retiring as fast in the wake of these other programs. Maybe I had that wrong, but
I'm not quite certain what Ms. Roberts was referring to. I'm not saying it doesn't exist, but I'm not certain what she's referring to.
Maybe I just threw her under the bus. Maybe she wasn't even talking about that.
Again, this has been going on a while. It's still going on. So there's a lot of orders that are inside and outside the record. I would just say to my first response is obviously the issue before the commission is what's in the record at that time when it's facing this. The commission in the Mystic orders had found that the processes, methodologies used by the system operator were reasonable. I think you'll see some discussion in there. Some of the environmental groups had indicated that things had changed a bit there, and the system operator responded indicating that may be the case, but also we used some very conservative assumptions that kind of undercut the fuel security, that underplayed the fuel security risk. So the commission found that on balance, it was a reasonable analysis. I mean, I will say, again, kind of to both your questions about whether the commission just blindly relies on the system operator, the answer is no. You see that by the fact that the commission recently rejected ISO New England's proposed long-term proposal here because it didn't think that it was reasonably calculated to address the risk. Whether the commission still views the fuel security, whether it still holds the water it did when the commission was looking at this back then. I think if you look at that, and I think it's a December 2020 order rejecting the ISO's long-term proposal, the commission does rely on it. And that's part of the problem, that the proposal by us, long-term proposal by ISO New England didn't really address some of the risks laid out in the fuel security analysis. I see I'm in the red. Unless there's any questions from the panel, I'll defer to our interveners.
All right, Judge Katsas, Judge Jackson.
All set.
All right, we'll hear from Mr. Hughes.
Thank you, Your Honor, and may it please the court, Paul Hughes for the New England Power Generators Association. I'd like to begin by focusing on three broad principles and then responding to several of the issues that have come up today. The first is, of course, there can be no serious dispute that absent action, New England faces severe risk of cold weather-induced blackouts. Second, FERC's approval of an interim program must be evaluated against the backdrop of this exigency. The question here is not whether ISO New England's program is a perfect one. It is whether FERC acted in an arbitrary and capricious fashion in determining that is it just at least one reasonable and just proposal. The need for a simple solution in a short period of time appropriately bears on that analysis.
Can you define the exigency, Mr. Hughes? What exactly are you saying was the exigent circumstance?
Here, Your Honor, the exigent circumstance was the extensive analysis that ISO New England took in 2018. They issued a report in January of 2018, and then in July of 2018, FERC identified the severe cold weather-induced blackout risk and directed ISO New England to take a response. ISO New England, from that time, in less than 8 months, put forth this proposal as an interim proposal only for 2 years. They had to act in that period of time because what ISO New England said in this proposal was critical in part was the forward-looking component of this. So it could send signals to resources not to retire. And Your Honor, to make those retirement delist bids, the record is clear that those had to be made for the winters of 23 to 24 by March of 2019. So from January, when this report was issued, to July of 2018, they had until March of 2019 to put in place a solution that would affect retirement determinations for the winter of 23 to 24.
And so what is the evidence that it actually is affecting or will affect, and to what degree it affects retirement determinations?
Thank you, Your Honor. So FERC engaged in relatively extensive analysis that this would have an effect on these signals. So for example, at records page 520 to 521, at paragraphs 95 to 96 of the decision, what FERC reasons is that providing these sorts of incentives create a pressure in the direction not for these resources not to retire. And this was against the backdrop, as been discussed, of 5,000 megawatts of fuel secure resources at the risk of retirement. Now, I note the court's point earlier that there could be more calculation as to tethering these, but the issue is for this interim proposal, is this sufficient for an agency to take interim exigent action? And we think the answer there is yes. We recognize that as ISO New England is working towards a permanent long-term solution, that the standards that the court may impose may well differ given the nature of the program. But for this program to have a solution in place for 2023 to 2025, we think FERC was well within its authority to adopt this as a particular solution. And let me add, I think it also bears noting, and this goes to Mr. Coyle's point about the pothole filling, the pothole unfilling. This program is already underway because the 2 capacity auctions for the summer or the winters that are at issue have already been run in February of 2020 and February of 2021. So the notion that the retirement decisions based on the inventoried energy program have already in fact been made. And as ISO New England points out in its brief at 11 to 12, of course, part of the nature of this program may well be to suppress the pricing in the forward capacity auctions. And the although it's quite complex and there are many factors, of course, that go into it. ISO New England does not say that the program is the sole basis. As a matter of fact, the forward capacity pricing has decreased. So that has occurred following the nature of this program. And so from the interveners—
Mr. Hughes, what impact, if any, is the other mitigating plans that were put into place to address the retirement exigency that you say exists?
Thank you, Your Honor. We can talk both about the cost of service and the pay for performance. So on the cost of service plans, first about the Mystic cost of service in particular, as I understand, the Mystics are still retiring in 2024, so won't provide the fuel security for the winter of 24 to 25 that's at issue here. But for the December 2018 FERC order that has a broader cost of service, there are a few different responses to that, Your Honor. The first is that paragraph 117 of FERC's decision, it recognizes that as well as the pay for performance and finds nonetheless that it's not a sufficient action. And I think there are a few reasons for that. As Mr. Kennedy explained, the cost of service mechanism in the December 2018 order is highly disfavored. It is an out-of-market solution entirely and is one that is of last resort. And I think it's notable that petitioners here try to criticize the—
Mr. Cruz, I'm not asking you whether it's a good thing, disfavored or not. I'm asking whether it works. What's the evidence that there was still a need for IEP even after you had these other programs?
Your Honor, I think that's found in ISO New England's study that underlies this, and that's the discussion that's at pages 138 to 100. Oh, I'm sorry, Your Honor. It's at appendix pages 351 to 352. That's the ISO New England's filing that provides more details as to why, against the baseline programs, there was additional need for the incentives to be created for fuel secure resources to remain online, not retire. That's the retirement incentive. And then the real-time incentives for other generators to ensure fuel secure resources. And one small point there, Your Honor, I think it's notable that the dissenting commissioner below and petitioners seize on the notion that they suggest 1/3 or so of generators or resources might inventory energy in the status quo or absent of the program. But that suggests on its face that 2/3 of those who would be responding to the program would not be inventorying energy in the status quo. I think that's rather compelling evidence that there will be a change in behavior that results from this program in a way that's quite important. And further to the notion that generators might engage in this activity, as I said at the outset, this is about also sending forward signals and for the auctions that have already occurred. I think that's relatively difficult to unwind at this point. But finally, to the point that the court has previously discussed, what the whole program turns on is the premise that inventoried energy provides a social good, that there is a utility that's based in it. And at the status quo, prior to the program, there was insufficient levels of inventoried energy to meet winter demand needs. It was reasonable for FERC to say, we need to create a market and provide a compensation basis, both on a forward basis and a spot basis, to ensure that if we don't have enough of this good, compensating for it to ensure that we get to socially useful levels of this. In many ways, this is just like the way the capacity markets operate generally. When one thinks about the capacity markets, of course, there are going to be generators out there who are going to be able to provide capacity even in the absence of a forward capacity market. But the reason that we have those capacity markets is because we recognize there has to be sufficient capacity and a guarantee of that sufficient capacity in the future for when it's needed. That's the same.
Mr. Hughes, can I ask you, if we disagree with you and we think that this matter needs to be remanded to the agency, no one really has talked about with or without Vacatur, and something that you raised in terms of the intertwined, the auctions are already happening, touches on that. So is it your view that if it were to be remanded, it would have to be without Vacatur because it would be disruption? My thought was that if there were a remand, it would be fine because this is about 2023, 2024. We haven't really done this yet. But explain to me what your point or what your view would be on with or without Vacatur.
Thank you, Your Honor. And of course, we think that the petition should be not denied, but answering the court's question, if the court were inclined to grant any petition, we absolutely think it should be without vacatur because of the fact that, again, we are midway through the process here. The auctions have already been run. The D-list bids have already occurred. We are years past that now for the delivery of the energy in the winters of 23 to 24 and 24 to 25. And so if, again, we disagree with this, but if the court were of the view that FERC needed more explanation for the result it reached, a remand without vacatur would be absolutely critical not to disrupt the system because all of the generators have bid into this market on the basis of the inventoried energy program's existence. Those are already determinations that have long since been made in markets that have since been constructed as a result. So again, we think that the petition should be denied, but barring that, any remand certainly should be without vacatur.
Thank you.
I'm happy to answer any
other questions, Judge Katsas, Judge Jackson?
Thing for me.
All right, we'll hear from counsel and rebuttal. We'll give you your 4 minutes.
Thank you for your generosity, Your Honor. I appreciate it. There's a lot to unpack in that discussion. Let me go back to Judge Jackson's question about vacatur first. Excuse me. I don't believe that forward capacity auction 15, which covers 24 through 25, has been run as yet. The bids for the FCA 14, which covers the 2023 to 2024, were submitted in alternative, an IEP in effect and a no IEP in effect. So that's relatively easy to sort. The more basic question that you have to confront when deciding on vacatur is whether the flaws in the underlying order are something that the agency can cure. And here, there is not a sufficient record or sufficient reasoning behind the record for the reasons we've detailed at length in our briefs and our arguments to enable the FERC to salvage this order. So absolutely, if you decide you have to remand with vacatur.
And so is that because there's not sufficient evidence in your view to support what FERC determined? Why can't they cure it with more of a reasoned or rational explanation?
The analysis, and I'm doing this loosely a little bit, Your Honor, but as I understand the courts, I believe it's the Allied Signal decision. You have criteria that guide the decision whether or not to grant vacatur, and typically the way the court applies those criteria is the deficiency in the order something that the agency is likely to be able to cure on remand with, for example, better explanation than they supplied, but it's plausible that the agency reached the right result.
Right.
Our position here is that the record before the agency does not furnish a sufficient basis for just fixing this order with an explanation, right? That the analytical defects are so egregious in this order that you have to vacate and tell the agency to start over again. Now, that's not an emergency. It takes literally 5 months to put a winter reliability program in place. So if there is a crisis, the way that worked for the previous 8 or 10 years can be made to work again. It's not like the lights are going to go off or people are going to suffer rolling blackouts. There are means to deal with this. Also, on the question, the impact on ongoing forward capacity auctions, as I said, one I believe that has occurred had alternative bids. To the extent I'm wrong about forward capacity auction 15, that auction occurred with full knowledge and notice that this case was on appeal. So bidders in that auction were able to factor that risk into their bids. There is no basis for remand without vacatur in this case. I wanted also to go back and revisit the question of misaligned incentives generally. and touch on a quick response to Judge Wilkins' observation that you can't put a price on reliability. In the crudest terms, the misaligned incentives slogan argues that the value of service to the customer is an appropriate basis for setting utility rates. FERC itself has held in Western Systems Power Pool, cited in our brief, 55 FERC paragraph 61099 at page 61,316, that value of service pricing to the customer is an attribute of monopoly pricing, right? You think about what the value of lost load is. It's tens of thousands of dollars per megawatt hour. Okay, if that is your ultimate limit on pricing, you are not producing just and reasonable rates. And yet, that is the end state of the misaligned incentives argument. There is no limiting principle on that argument. And it's for that reason, it is not a sound basis for setting a utility rate, and it certainly doesn't justify quintupling the cost to consumers of ensuring that the lights stay on in the wintertime, which is what this order does.
All right.
I'm about a minute time, so I'll thank the court and ask for remand with Vacatur. Thank you.
All right. Thank you. We have the argument. We will take the matter under advisement.
Thank you, Ron.
This honorable court is now adjourned until Friday, October 22nd at 9:30 a.m.